Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our coverage of Massachusetts versus Dr. Tuerk. And we are coming towards the end of this trial. We have day 8 and then the verdict. So we're closing in. When we last... sorry. I am the Squeegee. All right, if you're watching us live, it is a Saturday. We had a long stream yesterday. It was a long day yesterday, so just kind of trying to get my bearings here. So, therapist you know, dropping a $4.99 on us. Thank you so much for that. And Baka, Drunky the Bear. Oh, wait a minute, this is from yesterday. Hold on a sec. Okay, here we go. All right. Lily Wayne, there you are. Birdie B. Maddie's mom, good morning to you. Gordon, how are you doing? Shirley Roth, Golden Girl. There's Drunky the Bear coming in the morning. Oh, yeah, it's not so bad for you right now. Fala, good morning, chat. Virginia Little, great to see you. Susie, hello to you, only fan. Thank you guys for joining us on a Saturday. If you're live, it is Saturday. If you're on REWATCH, cool. It's whatever day it is for you. So, when we last left Mr. Tuerk here, Dr. Tuerk, he was on the stand, right? So we got through cross. So it'll be interesting. This next day is pretty long. Let me see. Day 8 is 5 hours and 36, not be the last one. And then day 9 is going to be the verdict, and that's only 8 minutes, so that'll be quick. So, hope you guys had a good morning, good afternoon, good evening, wherever you are watching. And let's get back into Dr. Tuerk. And for those that when we got cut off, that other stream, the day had ended. I was just doing a recap, and they cut us off because... well, I can't really say it because I don't want to get cut off again, but it was Dr. Tuerk, what he did in the hotel to himself. So you guys that watched, you know what happened. That's why YouTube did what they did. So I'm not even going to go there. So I don't know if it was something I said or something that we were showing pictures, if you guys remember. So we just have to be careful about that. So let's get back to, so you didn't miss anything. It was just my recap, which was, I was at the end anyway. So let's get to the, okay. Ooh, wow. Oh my goodness. I am really tiny squeegee there. That's obnoxiously tiny. Sorry, Katie. I don't mean to be in your chest there. All right. That was really tiny squeege. Talk about a pipsqueege. That is the epitome of pipsqueege. That's funny.
Okay, so...
Oh, looks like they're going to be continuing with cross again. So it looks like we're picking up with cross. Yeah, so hey Kelly, we were talking about him doing what he did to himself. And we were showing the pictures, kind of trying to determine if Katie was, had been scratching him while he was doing what he was doing. So I know because they told us that. They sent us an email, meaning YouTube. They sent us an email and said, are you okay? We're taking you offline. And our mods, we had to talk about that. Well, if you're in the middle of doing that and then they take you offline, that's probably not the best thing. But anyway. So, yeah, YouTube being very cautious, so nothing extreme. Hey, MG, I know you're at work. Well, hang in there. Hey, Karen, how are you? Thank you for joining us. I know, I fit like perfectly right there. All right, yep, so we're still on cross. Hey, Irish Amy, so appreciate you guys doing a weekend stream for us. Yeah, no problem. We got to finish this. We have to finish this trial before Monday because we're picking up on the Christopher Shores trial. All right, let's get to it. This is going to be, this is like 6 hours, and then the verdict is like 10 minutes. So we're going to be streaming for about 6 to 6.5 hours, just so you guys know. Just so you can plan accordingly. Make sure, is there CC? Oh yes, closed captioning. All right, let's get to it. So he's back on cross.
4 or 5 days.
Correct.
And certainly you had a washing machine and a dryer in your house, right?
Yes.
And can we have exhibit 238, please? You can see the washing machine and the dryer in this picture, right?
Yes, I bought that 5 years before.
All right, and there's a suitcase there,
Correct.
some folded laundry.
Yes,
Is that a suitcase that you took to Florida?
that's correct.
And that's your laundry that you were doing?
Not necessarily.
Okay. You can take that down, please. All right, let's talk for a little while about what happened in the bedroom. When you grabbed Katie's neck with one hand, you were on the floor, right? That's what you're saying?
At the time that she struck me, I was kneeling on the floor and begging her to stop.
So I'm asking about the point in time when you put your hand on her neck. Were you still on the ground at that point in time?
I was coming up from my knee, grabbed her with one hand and used the other hand to protect to check on my bleeding. Yes, I came up from my kneeling position, reacted to the threat of being struck.
So you were standing at that point in time?
I would say I was half standing toward the standing, probably. I don't really recall all that. I was pretty drunk.
All right, we'll talk about how drunk you were later, but I'm just trying to understand what you remember now about your position.
Well,
You were half standing, half kneeling. Katie was on the bed. How was she positioned?
She was sitting on the bed edge, as far as I remember.
And what was happening with her hands?
She had, as far as I remember, a phone in one hand and a glass on the other hand.
And she continued to hold the phone and the glass?
At what time?
As you were strangling her, she continued to hold those items?
No, she struck me with the glass.
Well, she struck you with the glass first, and then you reacted to that, right?
Correct.
So that had already happened.
Sorry, what?
That had already happened. So the glass wasn't in her head and in her hand anymore, right?
That's what I was trying to say, but you said she had her glass in her hand. That wasn't the case at that time anymore.
So as you were strangling her, what was happening with her hands?
I don't know if I strangled her. I said I think I choked her.
Are you distinguishing between choking and strangling?
All I'm saying is that I really don't know what I exactly did because I was drunk and I was in a fight and flight reflex. So I really don't recall much extra that I really grabbed and tried to protect myself or defend myself.
You remember putting your hand, at least one hand, around her neck, right?
I said I think I grabbed her.
I'm asking what you're saying right now. Not what you said in the past. I'm asking right now.
And I blacked out from the struck. I was assaulted at this point in time and I reacted and I believe I grabbed her.
When you blacked out, are you saying you passed out?
No, blacking out means that I didn't really recall what I was doing. I reacted to a threat.
So
I snapped.
Okay, so the glass hit your head. You snapped. You had a fight or flight reaction.
Correct.
And You just reacted. I'm sorry, you said something else that I just forgotten. You blacked out,
I snapped.
you snapped. What else are you attributing to the glass hitting your head?
Fight and flight reaction. I was afraid.
And you said yesterday you were afraid of having to leave 29 Valley, right?
I was afraid of Katie too.
You didn't say that yesterday.
Because you compared that to physical.
One at a time.
Sorry.
Yesterday you said you weren't afraid. You said you were afraid of 29 Valley, of having to leave 29 Valley.
I was afraid of Katie too, but not in the physical sense that you try to explain. But it's not about being bigger or stronger sometimes. It's about who has the power. And she had all the power after I signed everything over I had to her. And I was very afraid of her, with her intentions and her reactions. I was very afraid of Katie.
That was a shift in your relationship, right?
There was a massive shift in the relationship that she had massive leverage over me, yes. Yes.
All right. So at the point that she hit the glass in your head, she didn't have the glass in her hand anymore, right?
I don't think so.
So she had a phone in one hand.
At the time when she struck me, I don't remember or I don't recall what happened with the phone later or the glass, because it was all one blurred reaction to being hit.
Did you get on top of her?
As far as I remember, when I came out of my blackout, she passed out very quickly. There was no fighting, really, as far as I recall. But when I came back out of what the hell happened, we were both on the floor because we kind of slid off the bed and fell on the floor.
Were you on top of her?
I don't recall that.
Where were your hands when you were both on the floor?
I don't remember.
Were they around her neck?
Not sure.
Is it possible that you were slamming her head on the ground and that's how she got the injuries to the back of her head and her brain?
Well, we heard yesterday that wasn't trauma related.
I'm not asking about Dr. LaPosada's opinion. I'm asking about your testimony about what happened. And you have some gaps in your memory. So I'm trying to make sure that we understand exactly what you know happened and what you don't know happened.
Thanks.
So is it possible that you were on top of her with your hands around her neck, slamming her head on the ground?
I do not recall.
Is it possible that she put her hands on your hands in an effort to remove them from her neck?
There were no defensive wounds on Katie and no defensive wounds on me, so no.
I'm asking what you know about what happened.
Not that I recall. There was no struggle, no fight as far as I remember. I reacted to the hit. I felt threatened. I defended myself. And once I kind of recalled that I kind of came somewhat back, but I was still very intoxicated, we were both on the floor. And she was unresponsive.
Ms. Gilman, can we please have exhibit number 57? Could you zoom in, please? And Dr. Tuerk, put exhibit number 57 in front of you.
Please.
Yes.
Do you see this mark right here on your hand? On your finger?
On the middle finger, you mean?
Yep.
I see that mark, yes.
Isn't it possible that that's from Katie's fingernails?
No. Because there were no skin cells under her nails in the forensics.
About your memory, sir, not about the forensic evidence.
It's not possible.
Could you turn to 59, please?
59. I have it.
And do you see these injuries right above your thumb?
Yes,
Isn't that possible? That's from Katie's fingernails?
they were from the bushes I walked through, not from Katie.
And those were documented by the police, right?
I believe so.
All right. And that cut on your head, the police took efforts to document that, right?
Correct.
Gonna go lights back on. All right, let's talk about what you did after you killed Katie. You carried her out of the house, right?
My direct after? No.
Didn't say direct. Just said after you killed Katie, you carried her out of the house.
After a while, I carried her out of the house, correct.
Past the children in the bedrooms, right?
I carried her on my hands in the hallway, downstairs, into the garage.
Past the children in their bedrooms.
They were in the bedrooms, correct.
Down the stairs,
Yes,
into the kitchen,
yes,
into the mudroom,
yes,
into the garage.
yes.
And you put her in the Jeep.
I put her on the passenger seat of the Jeep.
And then you drove to the pond at 1 Francis Street.
Correct.
We have exhibit 133. You drove her there, right?
I don't think I drove with the Jeep exactly there. That's right on the water. There were bushes. You couldn't drive there.
There was too much brush, but that's the pond that you drove her to, right? In that photograph in 133?
I put her in the pond on 1 Francis Street, yes.
And you had been there previously.
Excuse me?
You had been there previously.
I was there 2 years before, looking at the house because Katie asked me to, because she wanted to possibly buy another house.
It's Katie's fault that you know about the pond?
Excuse me?
It's Katie's house that you know about the pond? It's Katie's fault that you know about this pond?
That Katie what?
It's Katie's fault that you know about this pond?
I didn't say that, no.
My question was that you had been to 1 Francis Street previously.
Correct.
And you knew that it was for sale. Could we have exhibit 309, please?
Yes.
So you knew it was unoccupied.
Yes.
Pulled all the way up.
Sorry?
You pulled all the way up next to the house.
I do not remember exactly how far I drove into that property. I don't know.
You told the police in the interview that you pulled all the way up, right?
I was struggling with memory when I gave that interview.
All right, should we get the transcript?
Thank you.
Can I just a minute, please, Your Honor?
May.
One more minute, please.
Yes.
Find that place where he parked by the top of the house. All right, let's come back to that. Certainly you'd agree that you didn't want to be seen putting Katie's body into the pond, right?
That wasn't a concern of mine, I believe.
That wasn't a concern of yours?
I didn't think about all that, no.
You thought about where to put her, right?
I was thinking about not having her being found in the house by her children, yes.
And you decided that the pond was the place to put her?
It took me a while. I was in panic. I couldn't really remember much of anything that happened, and I tried to figure out, where to go.
All right, so if you look at page 75, that's where you're talking about the garage, right?
Yes.
Did you park up by the garage, or did you park down closer to the pond?
Here, I'm saying right there, and then that's the garage. I don't know what I mean with that,
Okay,
because I was confused.
you were confused. Perfect. But you were able to give accurate directions to the pond, to the police, right?
I had no recollection of the street names at that time, again, showing that I was confused. I just told them right, left, because I couldn't remember the street names.
But you knew the names of the street ordinarily?
I did, used to, but not at that time. I was completely out and confused.
You were completely confused when you were speaking to the police?
Well, there was a lot of confusion, a lot of shock, a lot of grief. I just went through a trauma myself. I mean, it was a very traumatic event. I just wasn't shocked.
The event was traumatic to you?
Yeah, I didn't like to cause death of another human being. I spent all my life to save lives. So I was pretty much in shock myself of what happened. Yes, I was extremely sorry and guilty and shameful about what happened. Yes, I struggled with that throughout the whole interview. That's why you see all this, I don't know, I'm sorry, I don't know. I was struggling.
Let's go back to what happened on the after you killed Katie. All right. You took her out of the car, regardless of where you parked, and you traveled through all of the brush and the greenery around the pond, right?
I do not recall the botanical stuff, but I walked through brush to the pond. Yes.
Well, you just said the marks on your hands were from the brush.
Yes. Yes.
You're talking about this in 315, right?
No, there were also bushes a little higher. I remember that. there was a lot of resistance as I walked through.
And certainly the police documented that in their pictures as well, right?
That's where my scratches likely came from, yes.
Okay. And you had boxer shorts on?
Yes, we had sex, and I put the boxer short on. That's all I had on at the time of the event, the tragic event, and later on, correct?
All right. And you're saying that you didn't take Katie's shirt off?
I do not recall, no, I didn't take it off. I don't even remember that it was off.
So I mean, showing you what's been marked as Exhibit 308. Is this her tank top?
I believe so.
Is this what she was wearing when you killed her?
I think so, yes.
And I understand that you weren't able to look at the picture in Exhibit 146, but you're aware that there's a picture of that shirt on a tree branch, right?
I was told that that was on the tree branch, yes.
Okay. And certainly you didn't want a shirt ballooning up and helping Katie float, right?
I had no intention to think any of that. I just wanted to put her away.
Well, you said yesterday that you were concerned about her floating, right?
No, I did not say that.
So you said yesterday that you put the rocks in her after you noticed that she was floating, right?
I put her in the water as far as I recall. Again, remember that I had a lot of intoxication and I was struggling with the whole situation that I was extremely upset about myself. And as far as I remember, I put her in the water and I was kind of surprised she was floating.
Okay, so you were upset about yourself and you were intoxicated, I understand that. But when you put her in the water, did you push her out?
No, I was very careful with her. I just walked into the pond. I walked into the pond and put her gently down.
You walked into the pond and you put her gently down. And then did you turn around and walk back out to the shore?
No, I was looking and seeing she did not go underwater. As far as, again, I remember, and I was kind of, well, why isn't she going down?
All right, and you didn't want her to be discovered, right?
It wasn't really a concern of mine. I was going to kill myself.
But then why did it matter whether or not she wasn't going down?
Again, I was not really capable of rational thinking at that time. Sorry.
Well, if you didn't want someone floating, putting rocks in them would be a good idea. You'd agree with me about that, sir, right?
But rocks, I stumbled over them by accident looking for something to wear her down.
So you were looking for something to weigh them down, and you didn't put leaves in there, right?
Again, my rational thinking was massively impaired. I didn't think about any leaves or anything that you're suggesting. I just looked for something.
Well, I'm suggesting it's rational. If you want to weigh something down, you use rocks. You agree with me about that?
Again, you are assuming that I was fully capable of cognitive behavior, which I was not.
I'm not making assumptions, sir. I'm asking you a question about whether or not it's rational if you want to weigh somebody down to use something heavy like 2 large rocks.
Again, I wouldn't call it, I would use the word rational. I wasn't rationally thinking because I was completely drunk. Just reacted. I reacted to what I saw.
There's not a question before you, sir.
So I just wanted to, sorry.
You got the rocks. Where was Katie when you got the rocks?
She was still in the pond.
Did you go get her and bring her back to the shore? Or did you bring the rocks to her and stick the rocks in her pants while she was in the water?
I believe I brought the rocks to her.
And then she went down a bit, right?
Correct.
All right. So then you walked back to the Jeep,
Yes.
and you drove back to 29 Valley Road.
No,
You didn't drive back to 29 Valley Road?
not at that time.
Where'd you go?
I tried to go, I drove to the hotel first, or on the way to the hotel.
You drove to the hotel all the way?
No,
Part way.
partway.
How far'd you get?
I have no recollection again. I was completely out.
All right, you've never said that before though, have you?
I believe I said that I was on my way to the hotel, and I recognized that I didn't have my phone because I wanted to say goodbye to some friends.
Okay. So you realized that if you wanted to accomplish the task of saying goodbye, you would need to have your phone, right?
Again, you're subjecting, or you're assuming I had a lot of rational thinking going on. That wasn't the case. I just saw I didn't have any communication device, and I thought, let's go back and get my phone.
Because you understood that you could use the phone to communicate with people.
I'm not sure if I understood that, but I wanted to say goodbye, and I didn't have any tool for it.
Okay. And you understood that your phone was at your house.
I assumed.
It seemed like a logical place to look.
That's correct.
All right. And you changed into your jeans, right?
No, I didn't change. I didn't have much clothes on except my boxers.
You put your jeans on.
Correct.
Because that made sense. When you were walking into the hotel, it would make sense to wear jeans.
I didn't think about that.
Okay. And you also picked up your wallet, right?
Was coincidentally that I walked by it and grabbed it as well, yes?
Okay. And you picked up a bottle of whiskey.
I don't recall that.
Well, when you were in the Jeep, you had a bottle of whiskey next to you, right?
I don't know how often I have to repeat that. I wasn't really thinking clear.
I'm asking whether or not you had a bottle of whiskey. I'm sorry my questions seem repetitive, but if you listen to the question, you'll understand that they're different questions. So was there a bottle of whiskey next to you in the Jeep?
I don't know.
Do you want to see a picture?
If you have one, please.
All right, Ms. Gelman, can we have 106, please? That's a bottle of whiskey in the Jeep, right?
That's what the picture shows, yes.
All right, was there always or routinely a bottle of whiskey in the Jeep?
No,
All right. And the knife that's there, you said that that was typically in the glove compartment?
or let's say there was typically a knife somewhere in the car, mostly in the box, in the glove box, correct?
Did you take the knife out of the glove box?
I don't think that I did, or I don't recollect or recall any of that.
All right. When you were driving, were you drinking from that bottle of whiskey?
I have no idea. I don't know.
All right. But you left it in the car. You didn't bring it into the hotel with you.
The picture shows it was in the car, so must have left it there.
All right. And you drove back to Dedham.
I drove to the hotel to take my own life.
On some windy roads, right, sir?
I do not recall what kind of roads I was driving. I don't remember.
You didn't crash, though, right?
That was a miracle, I think.
I'm sorry, I didn't hear that. Can you say it again?
That was a miracle, I think,
Okay,
that I
thank you.
didn't crash, given the fact that I was completely intoxicated
And suicidal, right?
and suicidal.
But you didn't crash into anything.
I don't think so.
Okay. And you drove to the correct hotel,
Yes.
and you parked the Jeep in front of the hotel
I don't know where I parked it.
in a parking lot.
I do not know.
And it was between the lines, albeit close to the curb. We have exhibit 118. That's the Jeep parked in front of the hotel, right?
It appears that way, yes.
When you say it appears that way, are you uncertain?
I don't see the hotel really. I see a couple of windows and a wall. I don't know if that's the hotel.
Okay. And so let's have the video exhibit. Ms. Gilman, we have the second video from the residence in, please. What exhibit? Exhibit 278. Pause it, please. That's you, right?
Yes.
You have something on your face?
I don't know.
Go back. You wearing a mask?
I have no recollection of that.
Were there rules that you had to wear a mask in the hotel during this time period?
In May 2020, I believe there was a rule.
Okay. And that's you coming in, right?
I don't. It looks that way that I walk in. Yes.
You have your jeans on, your shirt, right?
Yep.
That's the jeans and the shirt that were introduced into evidence, right?
Yes.
Your belt,
I don't see a belt.
press play. Were you able to see a belt in the video?
No.
Would it make sense you had a belt on?
Probably.
Did it appear like your shirt was tucked in?
Yes.
So you went through the front doors of the hotel, and you had to use your key card to get in?
I don't remember if that was necessary. I don't know.
And you went to the correct room, right?
I went to my room. Yes.
It was at the end of that long hallway?
I have no recollection where it exactly was.
All right. And you took a knife to one of your wrists?
Sorry.
You took a knife to one of your wrists?
That's what. Again, I do not remember that act exactly, but I have a scar on my left wrist.
You have a scar?
I have a scar here on my left wrist. Yes.
All right. And the hospital characterized those marks as superficial. You aware of that?
No.
You didn't have any stitches or anything, right?
I do not know.
Were there any marks on your wrists that you were trying to cover up?
No, I wanted to kill myself.
No marks from Katie on your wrist?
Katie had no skin cells under her nails, so no.
Katie had your DNA under her nails, right?
I lived with her for 4 days, 24/7. That's natural to have some DNA on your hand.
Sure. But she did have your DNA under her nails.
I was all day with her, very much intimate. Yes.
All right. And certainly, Dr. Tuerk, you're aware that there are effective ways of slicing your wrists to initiate self-harm that results in death, right?
Yes.
And you got back to the hotel, into your room, and you started drinking again, right?
I have no recollection of that. I do not remember how I got to the hotel or what I did in the hotel. I was drunk, really drunk.
And isn't it possible that you drank more in the hotel room?
Certainly.
There was a bottle of whiskey also in the hotel room, right?
I drank basically all day, or not all day, but I started at 4 or 5 the night before, and continued because I was really scared about what Katie was trying to do.
Well, you weren't scared when you first started drinking, right?
No.
That was just fun drinking.
Sorry, what?
That was just fun drinking, right?
Yeah, she made martinis on the Cosmo, and we sat on the back deck and had a couple drinks, correct?
And then you weren't scared when you were drinking after you killed her, right?
I was in panic. I was definitely scared. My anxiety. No, but I was scared.
Okay. And you woke up in the hospital, right?
Yes.
They had pumped you full of IV fluids.
I don't know what they pumped into me.
All right. And you woke up in the early morning hours, right? On Saturday?
All I know is I woke up and I was in the ICU. I don't know what the time exactly or what day. I actually asked the gentleman what day it is.
But it wasn't until later in the day that you spoke with the police, right?
I think it was somewhere around 5.
So it was 30 hours after you had been taken to the hospital by the ambulance that you spoke with the police, right?
I do not know when I was taken to the hospital.
All right. Does it make sense to you that it was around 11 in the morning?
I really don't know. I think I was passed out.
All right, let's look at the medical records. May I approach? All right. May I approach?
Yes.
So, if we look at your medical records, you agree that by noon, you're getting results from testing, right?
Results or
Texting?
orders?
What is it? Texting?
Results from testing
Test. I'm sorry. Thanks.
by noon.
Was on May 15, 2020 at 12 noon.
Okay.
Actually, it says 12. It doesn't say AM or PM.
Well, but usually hospitals take, document things in military time, right?
Well, they're doing tests 24/7. So it could be AM
It could be AM or it could be PM.
because there is no specification of afternoon or morning.
Do hospitals normally do test results in military time?
I don't think so.
You don't think so?
No.
Okay. Well, certainly you're aware that the police arrived at sometime after 10 in the morning. Are you aware of that?
I think it was the afternoon when they arrived.
You think it was the afternoon when they arrived?
I believe so.
Okay. Let's just do one thing at a time. First of all, just so we're on the military time, you see this test indication on the 16th at 16:25?
Yes.
All right, so Norwood Hospital is using military time, right?
To that, yes.
Yeah, okay. May I approach?
You may.
I'm going to show you Dedham Police Report of Lieutenant Gonski. If you could just look and see if that refreshes your memory about what time the Dedham Police were called.
I don't know if that refreshing my memory is appropriate. I was unconscious. I was, I think, unresponsive, I was described. So that says here. What does it say here?
If it's not helpful, I'll take it back.
I don't know. What was the question?
If it's not helpful, I'll take it back. But you agree at least that you were speaking to the police after 5 o'clock
I think it was around 5 o'clock, yes.
on Saturday.
Excuse me. So the tragic events happened on the 15th, I believe. And the next day, 16, Saturday.
You killed her in the early morning hours, right?
I didn't intend to cause that.
Then you went back to the hotel. You were transported to the hospital sometime late morning on that
I don't
Friday.
know. I don't know what time. Again, I wasn't conscious at that time.
You agree you were transported to the hospital on Friday. You're not challenging that, are you?
If you're asking me what I remember is that I woke up in the hospital, so I must have been transported to the hospital, yes.
On Friday.
Yes.
And then you're speaking to the police after 5 o'clock on Saturday.
That's what it appears to be. Again, I asked them even what day it was.
And certainly you felt better after you told the police what you'd done, right?
No.
You didn't feel better after you told the police
No.
what you'd done?
I feel today terrible. Never really changed. I'm so sorry about all that shit. Sorry. I'm not feeling better. I never felt better about what happened.
Didn't feel better to say where she was?
Now you asked me if I felt better. I did not feel better. I feel guilty and ashamed from day one. And I wish I could make it all go away. I mean, in terms of having a return.
That would be better if you could bring her back to life.
I would love to bring her back.
But you can't.
Fortunately not.
And certainly you understood that one of the reasons that the police wanted to find her body was so that she could have a decent burial with her family, right?
Yes.
And you wanted to provide that as well, right?
Yes.
And the police were right about that.
Well, I think I was right about that.
Oh, you were right. No further questions.
Just a few. Counsel was asking you about the circumstances of the blow to your head, the crashing glass on your skin, and then your reaction with your hand. You recall those questions?
Yes.
Question as to any statements or whether or not there's any conversations. Did she say anything to you at that point?
Yes.
What did she say?
She said, get the fuck out of my house.
This is after the deed was signed, right?
Correct.
Did she say anything else about the car or the hotel?
Yes, she said a lot of things. She was yelling at me for
What did she
over
say
an
about
hour.
the car in the hotel?
About the car in the hotel. She said, get the fuck out of my house and you can walk to the hotel because the car is mine. The judge said so.
Now, I'm going to approach you with the phone dump that was performed of your phone and Ms. McLean's phone. Now, your phone, if I am correct, was 617-594-8962.
I have a hard time remembering after 5 years. I think it sounds right.
And you were obviously carrying the phone as Ingolf Tuerk, right?
Correct.
And Ms. McLean's phone was 339-222-9407, correct?
Correct.
And the two of you were texting back and forth, right?
Correct.
Now, have in mind the time frame counsel was going over would be, obviously, you met and the two of you lived together for 2 years, right?
Correct.
Then you got married for about 5 weeks, maybe 5.5 weeks, and then the divorce, right? Was implemented?
Yeah, I wanted
Yes.
the divorce because
Yes.
I wanted to move on.
Just answer my question.
Yes.
During the period of time you already detailed, and counsel asked about the trailers and all that, you stayed at a lot of places, right?
Yes.
And you were concerned about the pandemic and dying, bluntly.
I
right?
was scared to death, yes.
During the April month, is that when Kurt reached out to you, your friend Kurt reached out to you on a FaceTime and had you speak to Ms. McLean?
That is correct.
And was that the time that, tell us what was said at that point.
I do not recall the exact conversation. It was a pretty lengthy conversation, but the essence is, Harry, I still love you. Come home. But there are conditions. You have to.
So you ultimately adhered to those conditions, correct?
I had to.
And you signed the deed,
I had to.
and you signed the post-up,
I had to, yes.
and you heard the attorney, and you saw the letters. You know the attorney, your own attorney, advised against this, correct?
Yes, he said that you shouldn't do that.
But you did it anyway.
I was so desperate for a safe place to be that I did it, yes.
Did you really think during this period of time, April into May, that the two of you were going to be reconciling? Did you feel that things were going to be good, you guys were going to love each other again?
I kind of was hoping for it because I didn't see much other choice than going back home. I didn't have a place to stay. I wanted to go back in my home.
Counsel had asked you about the sex and the frequency and things of that nature, correct?
Yes,
Would you agree with me, sir, that there were a number of text messages where she would text you?
Objection is to form.
Form, okay?
Just rephrase it, Mr. Reddington, please.
Sorry, Judge?
Just rephrase it.
Yes, thank you. I'm going to approach you with, this would be on May 5, 2020. This is a text from, let's abbreviate it, 9407 to Ingolf Tuerk, 8962. So that would be...
Can I just have a minute, please?
Yes.
That would be on page 1501. So I'm approaching you, sir, and handing you what appears to be a list of text messages from the Celebrate phone dump. Does that appear to be text between you and Ms. McLean?
yes.
All right. And what's the date of the text messages? Representative, just read it.
Here on this page, May 5,
So this is May 5.
correct.
Now, on May 5, had you actually started living back with her again? Are you still in the hotel, but you were
And May 5, I was in Florida still.
still in Florida?
Yes, sir.
Okay. At that point, you're telling the jury that she had indicated that she wanted you home, right?
Correct.
You guys are going to love each other again, right? Yes?
You tried.
Look on that text and see.
This one here?
There's an indication. May 5, 2020. You're right, with the foundation of text from her again. Can that be brought up on the screen?
Could we approach?
Yes.
Recall your testimony, sir, indicating that there were, on a number of occasions, that sex was a very important aspect of this relationship, correct?
Correct.
And in reference to text messages between yourself and Ms. McLean, I'm going to
Sorry.
ask that you on May 5, 2020, there was a discussion between you and Ms. McLean telling you to come home, and then the next box says, and come home and have sex with you.
Sorry.
Is that indicative of the type of text that you received from her?
Yes.
Now, in reference to counsel's questioning about the menstrual period and the blood that was on the bed, you heard the testimony from the DNA person and the crime guy talking about there was a round spot of blood on the bed, right?
Yes.
You were asked questions on cross-examination from the district attorney as it relates to the nature. No, didn't anybody wash the bedclothes and things of that nature, and show you photographs of your washer and dryer, right?
Right.
On May 6th of 2020, page 1526, it would be text number 4074 through 4077, please. Do you recall receiving, it's right there, do you recall sending her texts and referring to you to her? I will like you for the rest of my life. And the two of you are making arrangements for you to go over there and meet up with her on May 6th. Do you recall those texts?
Meeting up with her?
Yeah, over at the house, yep.
May 6th, I was still in Florida.
Okay. Do you recall her telling you to come home? When did you come home?
I drove back from Florida to
When? What was the date?
7, and then 8 I arrived in Massachusetts, and we went to the hotel and had sex.
Okay.
First thing, twice. She wanted that. And then I went home on May 10th, sorry.
May 10th, that's the answer. Do you recall on May 7th, that would be page 1529, and she sent you a text, "Good morning, I am excited to have you come home safe." Do you recall that text?
Yes.
On May 6th, do you recall discussing between the two of you, your coming home and being with her?
Yes.
You recall on May 6th would be 1526, discussing coming back together. You asked, "What if you don't like me anymore?" Strike that, I apologize. That was a text from Katie to you. "What if you don't like me anymore?" Your response, "I love you, Katie, you are my wife. I will like you for the rest of my life." And then she responded, "Okay, well, I have my period now, and most likely will still Friday, so not sure about sex." That was on May 6th in the afternoon.
I recall that.
And one of the addressing May 9th, which would be right after the 6th, do you recall her sending you texts, page 1541, where she texted you, "I love you, Harry Tuerk. Last night was the very best lovemaking I ever felt. I felt so safe and connected to you, with you, thank you. I love you, etc. You blew me away, Harry, both times, but that second time you were all there, all in."
I recall that text messages, yes.
And in between the text messages and your feelings, state of mind that the two of you were going to be husband and wife, get back together again, did you have any knowledge whatsoever that Kurt, your friend, was having practically daily conversations with her, including asking to show him her boobs?
Objection beyond the scope.
Okay, overall, just a yes or a no.
I did not know.
But nevertheless, one of the issues that was of import was the signing of the deed, correct?
That was very important to her.
You recall that she berated you about the fact that you sent the deed to your lawyer instead of sending it directly to David.
Objection.
No, overall.
Yes, she was angry with me that I delayed the arrival of the deed.
And ultimately, it was recorded, correct?
It was recorded actually on the day when the tragic events happened. It was one of her things. She yelled at me.
That's all I have, Laura. Thank you.
Nothing further.
Okay, you may step down. May I see counsel, please?
As it the issue of the defendant's request that the court entertain the instruction on involuntary manslaughter as it dovetails into intoxication, citing, as I did yesterday, the Santa case. I know that Your Honor had responded about the Garabedian case, and I just would like to just point out, maybe Your Honor would reconsider that. I think it's absolutely totally different set of facts on the cases. Garabedian, and this is back in '87, and I remember it like it was yesterday. The guy was intoxicated involuntarily because of pesticides that he was applying to this poor woman's lawn, and she caught him urinating, and he was berated by her for urinating on her lawn, and he then, according to the opinion, strangled her, and then went far beyond the needs needed to inflict death. Her body is then on the ground, and he then proceeds to smash her head with rocks and boulders so hard that her head actually made an indentation into the ground, bleeding into the ground. He then picked up like a string from her sweatshirt and strangled her again. And of course, the SJC indicated that in that set of facts, the issue of voluntary intoxication, would not justify the doing of an act in a sudden sense that carries with it, unfortunately, the death of the person as a result, but where the defendant is intoxicated and his judgment is significantly impaired in that very brief act, that I go back to Santa, and I think that there should be an instruction on involuntary intoxication. So I just wanted to put that on the record.
Involuntary manslaughter?
I'm sorry, yes, involuntary manslaughter, thank you.
All right, does the Commonwealth want to respond?
The Commonwealth maintains its objection from earlier.
Do you want to put anything else on the record with respect to Garabedian or Santa?
The Commonwealth would put on the record Commonwealth v. Linton, 456, Mass 534. That's a more recent case on manual strangulation, where the evidence, I would suggest, especially the medical examiner's evidence, was similar to this case. And again, the defendant's testimony and statements made yesterday that he, even in an intoxicated state, would know that cutting off someone's air supply via choking or strangulation would lead to death, Your Honor, would be the points the Commonwealth puts on the record.
All right, so Mr. Reddington, your objection is noted. I'm not prepared to give it based on the record and based on the arguments that both you made and the Commonwealth made earlier today and then just now.
And I think I have to renew the Rule 25 as well.
Okay, do you want to be heard on that again?
Waive argument.
All right, does Commonwealth want to respond?
No, thank you.
Okay, so I'm going to deny it for the same reasons that I did earlier. There's certainly enough evidence for a reasonable jury to find guilt beyond a reasonable doubt, and that's viewing the evidence in the light most favorable to the Commonwealth. All right, anything else?
No.
No, thank you.
Okay, I'll have copies for you when you come back.
All right, while they take their little break, we shall take ours as well. No, we're not going to take a break. We're going to go through what we just heard. Okay, so they picked up on Cross. He was on the floor begging Katie to stop yelling at him when she struck him. He said he was coming up and he grabbed her with the right hand and he was protecting his face with the other. He was half standing but was pretty drunk, so he doesn't really remember. Katie was on the bed, sitting on the edge with the phone in one hand and the glass in the other. So she smashes him. I guess the glass doesn't break. I said, I think I choked her. I really don't know why I really don't know what I exactly did because I was drunk and was in a fight or flight reaction. I was afraid. I think I grabbed her. So right now, what are you saying? I was assaulted and I reacted and I believed I grabbed her. So blacking out means I don't remember what happened and he snapped. See, I thought that you couldn't use that as an excuse anymore. I didn't think that you could say, oh, I was drinking and then I was driving. Well, you can't say that for sure, but I didn't think you could say, oh, I just, was doing all this stuff and then I just lost my mind and did that. I didn't think that was an excuse anymore. All right, I was afraid of Katie, not because of her physically, but of her power. Massive shift in relationship, and she had massive leverage over me. She passed out very quickly then I came back out of it, and we were both on the floor. We slid off the bed. We heard, so the state's like saying, well, were you on top of her slamming her head into the floor? And he's like, well, we heard yesterday Katie's injuries weren't trauma. So he's like testifying. I guess he's a lawyer now. Was it possible you were on top of her, slamming her head onto the ground? He says, I don't recall. Is it possible Katie put her hands on yours to remove them? There were no defensive wounds on her. Oh, there were no defensive wounds on us, so no. We were both on the floor, and she was unresponsive when I came back from my blackout. And he's like, there were no skin cells under her nails. And state's like, I'm not asking about the forensics. The injuries on his hands were from the bushes and not from Katie. After a while, I carried her out of the house in my hands down the stairs. The kids were in the bedroom, right? So these kids are in the bedroom. So he left these kids unattended. Anything could have happened to those kids, right? They could have woken up. Fire could have started. Somebody could have robbed them. Anything. He had been to this. So he put her in the passenger seat in the Jeep, and he drove to this pond. So they had gone to this place, 1 Francis Street. I guess the house was for sale, so they were looking at it. So he knew there was a pond there. He was thinking about Katie not being found. I was in shock. It was traumatic to me. Oh, it was traumatic to him. I spent all my life trying to save lives. I was extremely sorry, guilty, ashamed. I guess, what are you going to say? Anything he says, I'm going to come down on him. So he can't really say anything that I'm going to be okay with. He said that they got together. Then he put on his boxers. He doesn't recall taking Katie's shirt off. I just wanted to put her away. Ooh, ouch. Sorry, guys. Oh my, hold on. That's obnoxious. Let me turn that down. Let's see. There was a lot of resistance as I walked through the brush, and that's where my cuts came from. He's like, he doesn't recall taking off her shirt. Oh, wait, we got that. He walked into the pond and put her gently down. She did not go under the water. Why isn't she going down? Then he wanted to take care of himself. He wasn't capable of rational thinking. He stumbled over rocks while he was looking for something to weigh her down. Yeah, like the state said, you're not looking for leaves. You're looking for something heavy, like rocks, big heavy things, logs, whatever. Although logs might float. He believes he brought the rocks to kill Katie. He walks back to the Jeep and he drove to the hotel. So he drove halfway. He has no recollection, but he realized he didn't have his phone because he wanted to say goodbye to some friends. He's like, you're assuming I had rational thought at this time. He had enough thought to get a bottle of whiskey. And then states like, sorry, my questions are repetitive, but if you listen, you'll understand they are different. So he got to the hotel somehow without causing an accident. He parked between the lines. We saw the park. It wasn't like, he was like, he didn't park sideways. He walked in. So he had a mask on. He had jeans and a shirt. So he had enough wherewithal to know that he had to wear a mask. And he had a key card. So he had enough wherewithal. He didn't bump into the he wasn't so out of it that he bumped into the doorway and he's pounding, let me in. No, he had his key card. We saw the video. I don't remember him having a mask on, but I definitely remember he had jeans on, his shirt, and he used a key card. So he had enough wherewithal. He had enough wherewithal to make sure he had a mask. He wasn't trying to hide Katie's marks when he was doing what he did to his wrists. Katie didn't have skin cells under her nails. I was with her all day and was very intimate. He makes sure that he tells us that he was forced to get with her all these times. Dude, just say no or stop complaining. 30 hours after he had been taken to the hospital, he doesn't know when he was taken. Then let's look at the medical records. I don't know if refreshing my memory is appropriate because I was unconscious. And then he's like, so sorry about and he swears and he's like, sorry. Did not feel better telling the police he wished he could bring Katie back. He wanted law enforcement to find Katie so she could have a decent burial. And then redirect. Katie said, get the F out of my house. Oh, she was yelling for over an hour. You can walk to the house because the car is mine and the judge told me. And then we hear about Kurt FaceTiming and Katie wanted to speak to Harry. I still love you. Come home, but there are conditions. He had to adhere to those conditions. He had put her on the deed. He had to sign a prenuptial. His own attorney advised him against it. Then why go back? Oh, because he wanted to be in the house because he was afraid because COVID. He was hoping that they would reconcile. They did it on the bed, and there's blood on the bed. Why they didn't clean that up, I have no idea. That's just wrong. Katie wanted to have, when he got back from Florida, straight away, Katie wanted to jump on him, and they did it twice. Did you know Kurt was having daily conversations and showing, her chest, and he did not know that. I think that was objected to. I don't think that was struck. So. All right, what are you guys saying? Hey, Christy G, thank you for joining us. Good to see you. Ken saying hello to you. Hi, all. Joining late. Glad to be here. Cool. Yeah. Okay, Kathy. Just say no. I mean, how difficult is it for a big guy? He's like 6'3", 220, and he can't say no to a 5'7", 130-pound. I mean, come on, man. Never met a lady like this. Lily Wayne, he remembers what he wants to. Yep. Yeah, therapist, I forget my key card sober. I know, right? MG, he was so intoxicated he was able to think on what he could find to sink her. Give me a break. Yeah, he was aware. I agree. Yep, therapist, looking for rocks intentionally. MG, Lori should sing in her baby voice to him. Take my breath away. Right? Hey, Hellcat, thank you for joining us. Ken says, specific intent means an intent to commit the criminal act, actus reus, the strangulation, with the specific intent to cause a particular result. So, do you guys think, answer our question, answer our poll. 41 votes. Oop, all right, looks like they might be coming back. But that's good, Ken. Just Shamrock. Okay, y'all, I'm hitting the road and we'll be listening along. My first stop will be UC Davis. Any trial trivia folks know a case with a witness from there? Wow, UC Davis. Is that in California? Where's UC Davis? All right, Lily Wayne, we'll see you later. He got tricked into marriage, wanting to get out of it. Then he comes pining back for her. I know. All right, I'm going to end the poll. Let's see what you guys say. We're going to end the poll. MG, Chad could watch him take Loretta away from Lori because Loretta possessed her, right? All right, so 41 votes. Is Dr. Tuerk testimony helping or hurting him? We got 41 votes. Is Dr. Tuerk's testimony helping or hurting his defense? Hurting. Hurting is 65%. 34% think it's helping his defense. All right. Golden Girl, I don't believe any of his story. I know. Hey, DSN, thank you for joining us. Where is UC Davis? I think that's... Isn't that in California? Yeah, okay, it is California. Where in California is it? University of California, Davis. Where is this? It's up by San Francisco. So it's northeast of San Francisco. Is that the California? The guy that just got caught, that old guy, the cop? Is it that one? Was it the Golden State, whatever? I'm going to go with that one. Hey, Abe, thank you for joining us. Good to see you. Yes, the C is for California, University of California, Davis. And it's, I'm going to guess that's the Golden State, whatever they called him, that guy that just got caught. He was a cop, and he deleted a bunch of people. Oh, Karen Reed case tested for the dog DNA. Okay, cool. Carlos Dominguez, no. You're being silly now. All right. Abe, hope you're doing well. Good to see you. I didn't see you coming in. Oh, other than the your comment there. Okay, cool. This guy is off the radar, MG says. All right, B is for banana. All right, let's fast forward here. Let's do some zoomy. Ooh, that's a long break. Wow, that's a long break. Okay.
All right, jurors, welcome back. What I'm going to do is I'm going to hand out the legal instructions. You're each going to have a copy. You can put your juror number right on there when you get them. What I would ask you to do is not to read ahead, but read along with me. Please don't read ahead. Counsel, you have them as well?
Yes, Judge, thank you.
All right, everybody has a copy? All right. So, jurors, thank you for serving on this jury. You are responsible to uphold the law and our principles of justice. That is what you promised to do at the start of this trial when you took your oath as a juror. Don't be influenced by any personal likes or dislikes or opinions, prejudices, biases, or sympathy. You must carefully consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt that the defendant is guilty of the crime charged in this case. The final part of this trial will take place in 3 steps. I'll give you instructions about the law for the specific charge in this case. Then the attorneys will make their closing arguments, where they will highlight the evidence that they think is important and will argue in favor of the conclusions that they ask you to reach. The defense attorney will argue first, and the prosecutor will argue last. Again, that is because the burden of proof is always on the prosecution. After the closing arguments, I'll give you general instructions that apply in every case. You'll then work together to reach a verdict. Please pay close attention to my instructions, which you must follow, even if you do not agree with them. To make sure that I give you the instructions accurately, I'll read them to you. You'll also get written copies so you can refer to them in the jury room during your deliberations. So let's talk about the prosecution's burden of proof and the presumption of innocence. There is a fundamental rule that applies in all criminal cases. Every person who is accused of a crime is presumed to be innocent of that crime. All of us are entitled to that presumption under our Constitution. The defendant, Ingolf Tuerk, is presumed innocent of the charge in this case. That means you must consider the defendant to be innocent unless the prosecution has proved, beyond a reasonable doubt, through evidence presented during the trial, that the defendant committed the crime charged. I will explain what I mean by reasonable doubt in just a moment. The defendant does not have to do anything to convince you he is innocent. He does not have to explain anything. He does not have to testify, call or question witnesses, or provide any evidence at all, because you must presume that he is innocent. Instead, it is up to the Commonwealth to prove the charge against the defendant beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you've considered all of the evidence carefully and fairly, if you have a reasonable doubt about the defendant's guilt, then your verdict must be not guilty. You may find the defendant guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. So the burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charge made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all of the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. Now, since this case raises a question as to whether the defendant properly used force to defend himself from attack, I'll provide you with instructions concerning the law governing the use of deadly force in self-defense before discussing the elements of the crime of murder. A person is not guilty of any crime if he acted in proper self-defense. When I use the term proper self-defense, I'm distinguishing self-defense as both justified and proportional, and therefore a complete defense to the crime, from self-defense that is justified, but where excessive force is used. It is the Commonwealth's burden to prove beyond a reasonable doubt that the defendant did not act in proper self-defense. The defendant does not have the burden to prove that he acted in proper self-defense. If the Commonwealth fails to prove beyond a reasonable doubt that the defendant did not act in proper self-defense, then you must find the defendant not guilty. The law does not permit retaliation or revenge. The proper exercise of self-defense arises from necessity of the moment and ends when the necessity ends. An individual may only use sufficient force to prevent occurrence or reoccurrence of the attack. The question of what force is needed in self-defense, however, is to be considered with due regard for human impulses and passions and is not to be judged too strictly. The Commonwealth satisfies its burden of proving that the defendant did not act in proper self-defense if it proves any one of the following four propositions beyond a reasonable doubt. Number one, the defendant did not actually believe that he was in immediate danger of death or serious bodily harm from which he could save himself only by using deadly force. Deadly force is force that is intended or likely to cause death or serious bodily harm. Number two, a reasonable person in the same circumstances as the defendant would not reasonably have believed that he was in immediate danger of death or serious bodily harm from which he could save himself only by using deadly force. Number three, the defendant did not use or attempt to use all proper and reasonable means under the circumstances to avoid physical combat before resorting to the use of deadly force. Number four, the defendant used more force than was necessary. The defendant used more force than was reasonably necessary under all of the circumstances. I'll not now discuss each of these four propositions in more detail and remind you that the Commonwealth may satisfy its burden of proving that the defendant did not act in proper self-defense by proving any one of these propositions beyond a reasonable doubt. The first proposition is that the defendant did not actually believe that he was in immediate danger of death or serious bodily harm from which he could save himself only by using deadly force. The second proposition is that a reasonable person in the same circumstances as the defendant, would not reasonably have believed that he was in immediate danger of death or serious bodily harm from which he could save himself only by using deadly force. In considering whether or not the defendant actually believed that he was in immediate danger of death or serious bodily harm, and the reasonableness of that belief that he was in such danger, you may consider all the circumstances bearing on the defendant's state of mind at the time. Moreover, in determining whether the defendant was reasonably in fear of death or serious bodily harm, you may consider any or all of the following. Number one, evidence of the deceased's reputation as a violent or quarrelsome person, but only if that reputation was known to the defendant. Number two, evidence of other instances of the deceased's violent conduct, but only if the defendant knew of such conduct. And number three, evidence of threats of violence made by the deceased against the defendant, but again, only if the defendant was aware of such threats. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of the effect on the defendant of his consumption of alcohol, in determining whether the defendant actually believed that he was in immediate danger of serious bodily harm or death, but not in determining whether a reasonable person in those circumstances would have believed he was in immediate danger. A person may use deadly force to defend himself even if he had a mistaken belief that he was in immediate danger of serious bodily harm or death, provided that the defendant's mistaken belief was reasonable based on all the circumstances presented in the case. The third proposition is that the defendant did not use or attempt to use all proper and reasonable means under the circumstances to avoid physical combat before resorting to the use of deadly force. Whether a defendant used all reasonable means to avoid physical combat before resorting to the use of deadly force depends on all of the circumstances, including the relative physical capabilities of the combatants, the weapons used, the availability of room to maneuver or escape from the area, and the location of the assault. A person must retreat unless he reasonably believes that he cannot safely do so. A person need not place himself in danger or use every means of escape short of death before resorting to self-defense. The fourth proposition is that the defendant used more force than was reasonably necessary under all the circumstances. In considering whether the force used by a person was reasonable under the circumstances, you may consider evidence of the relative physical capabilities of the combatants, the number of persons who were involved on each side, the characteristics of any weapons used, the availability of room to maneuver, the manner in which the deadly force was used, the scope of the threat presented, or any other factor you deem relevant to the reasonableness of the person's conduct under the circumstances. So let me talk about murder. There are two different degrees of murder: murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree by the following theories: murder with deliberate premeditation and murder with extreme atrocity or cruelty. To find the defendant guilty of murder on either of these theories of murder, you must be unanimous. That is, all the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory on which you agree unanimously. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt that the defendant is guilty of murder in the first degree or murder in the second degree, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of the lesser offense of voluntary manslaughter. So I will begin by instructing you on the elements for murder in the first degree. I'll next instruct you on murder in the second degree. I'll then instruct you on voluntary manslaughter. Murder in the first degree with deliberate premeditation. I'll first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. First, the defendant caused the death of Kathleen McLean. Second, the defendant intended to kill, that is, the defendant consciously and purposely intended to cause the death of Kathleen McLean. 3, the defendant committed the killing with deliberate premeditation, that is, he decided to kill after a period of reflection. 4, the defendant did not act in proper self-defense. And 5, in addition to these elements, the Commonwealth must also prove that there were no mitigating circumstances. I'll now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Kathleen McLean. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Kathleen McLean. That is, the defendant consciously and purposefully intended to cause her death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from the decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. In deciding whether the defendant intended to kill Kathleen McLean and whether he formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant was affected by his consumption of alcohol. A defendant may form the required intent and act with deliberate premeditation even if he consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved these elements. The next element is that the defendant did not act in proper self-defense. I have already instructed you as to the circumstances under which a person may properly act in self-defense. Finally, the Commonwealth is also required to prove beyond a reasonable doubt that there were no mitigating circumstances. The law recognizes that in certain circumstances, which we refer to as mitigating circumstances, the crime is a lesser offense than it would have been in the absence of a mitigating circumstance. A killing that would otherwise be murder in the first or second degree is reduced to the lesser offense of voluntary manslaughter if the defendant killed someone under mitigating circumstances. Not every circumstance you may think to be mitigating is recognized as mitigating under the law. In this case, the mitigating circumstances that you must consider are 1. Heat of passion on a reasonable provocation. 2. Heat of passion induced by sudden combat. 3. Excessive use of force in self-defense. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt that there were no mitigating circumstances. I'll instruct you on each of these mitigating circumstances in more detail later when I discuss voluntary manslaughter. Murder in the first degree with extreme atrocity or cruelty. Next, I'll define the elements of murder in the first degree with extreme atrocity or cruelty. You shall consider this theory of murder in the first degree, regardless of whether or not you find the Commonwealth has proved murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. 1. The defendant caused the death of Kathleen McLean. 2. The defendant either A. intended to kill Kathleen McLean, or B. intended to cause grievous bodily harm to Kathleen McLean, or C. intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. 3. The killing was committed with extreme atrocity or cruelty. 4. The defendant did not act in proper self-defense. And 5. In addition to these elements, the Commonwealth must also prove that there were no mitigating circumstances. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Kathleen McLean. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant A. intended to kill Kathleen McLean, or B. intended to cause grievous bodily harm to Kathleen McLean, or C. intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, this second element has 3 sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to Kathleen McLean. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the decedent's death. If you find that he intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant, it should say defendant there, was affected by his consumption of alcohol. The third element is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in any taking of human life. You must determine whether the method or mode of a killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's action in terms of the manner and means of inflicting death and on the resulting effect on the victim. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death of the deceased with extreme atrocity or cruelty, you must consider the following factors. 1. Whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2. Whether the defendant's method or means of killing the deceased was reasonably likely to substantially increase or prolong the conscious suffering of the victim. Or 3. Whether the means used by the defendant were excessive, and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered, C, the manner, degree, and severity of the force used, and D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the three factors I have just listed. A murder committed by a single blow may be extremely cruel or atrocious where there's evidence of one or more of these three factors. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of the effect on the defendant of his consumption of alcohol in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killing with extreme atrocity or cruelty. The fourth element is that the defendant did not act in proper self-defense. I've already instructed you about when a person properly may act in self-defense. In addition to these elements, the Commonwealth must also prove that there were no mitigating circumstances. I've already mentioned that. I will instruct you on mitigating circumstances later when I discuss voluntary manslaughter. Murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of Kathleen McLean. 2, the defendant, A, intended to kill Kathleen McLean, or B, intended to cause grievous bodily harm to Kathleen McLean, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. 3, the defendant did not act in proper self-defense. And 4, in addition to these elements, the Commonwealth must also prove that there were no mitigating circumstances. If the Commonwealth proves all the required elements, but fails to prove beyond a reasonable doubt that there were no mitigating circumstances, you must find the defendant not guilty of murder, but you shall return a verdict of voluntary manslaughter. The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity or cruelty. Voluntary manslaughter. To prove the defendant guilty of murder in the first or second degree, the Commonwealth is required to prove beyond a reasonable doubt that there were no mitigating circumstances that reduced the defendant's culpability. A mitigating circumstance is a circumstance that reduces the seriousness of the offense in the eyes of the law. A killing that would otherwise be murder in the first or second degree is reduced to the lesser offense of voluntary manslaughter, where the Commonwealth has failed to prove that there were no mitigating circumstances. Therefore, if the Commonwealth proves all the required elements of murder, but fails to prove beyond a reasonable doubt that there were no mitigating circumstances, you must not find the defendant guilty of murder, but you shall find the defendant guilty of voluntary manslaughter. I'll now instruct you each of these mitigating circumstances. 1, heat of passion on reasonable provocation. Heat of passion includes the state of mind of passion, anger, fear, fright, and nervous excitement. Reasonable provocation is provocation by the person killed that would be likely to produce such a state of passion, anger, fear, fright, or nervous excitement in a reasonable person as would overwhelm his capacity for reflection or restraint, and did actually produce such a state of mind in the defendant. The provocation must be such that a reasonable person would have become incapable of reflection or restraint and would not have cooled off by the time of the killing, and that the defendant himself was so provoked and did not cool off at the time of the killing. In addition, there must be a causal connection between the provocation, the heat of passion, and the killing. The killing must occur after the provocation and before there is sufficient time for the emotion to cool and must be the result of the state of mind induced by provocation rather than by a pre-existing intent to kill or grievously injure, or an intent to kill formed after the capacity for reflection or restraint has returned. Mere words, no matter how insulting or abusive, do not ordinarily by themselves constitute reasonable provocation. Reasonable provocation does not require physical contact, but physical contact, even a single blow, may amount to reasonable provocation. Whether the contact is sufficient will depend on whether a reasonable person under similar circumstances would have been provoked to act out of emotion rather than reasoned reflection, and on whether the defendant was in fact so provoked. The heat of passion must also be sudden, that is, the killing must have occurred before a reasonable person would have regained control of his emotions, and the defendant must have acted in the heat of passion before he regained control of his emotions. If the Commonwealth has not proved, beyond a reasonable doubt, the absence of heat of passion on reasonable provocation, the Commonwealth has not proved that the defendant committed the crime of murder. 2. Heat of passion induced by sudden combat. Sudden combat involves a sudden assault by the person killed and the defendant upon each other. In sudden combat, physical contact, even a single blow, may amount to reasonable provocation. Whether the contact is sufficient will depend on whether a reasonable person under similar circumstances would have been provoked to act out of emotion rather than reasoned reflection, and on whether the defendant was in fact so provoked. The heat of passion induced by sudden combat must also be sudden. That is, the killing must have occurred before a reasonable person would have regained control of his emotions, and the defendant must have acted in the heat of passion without cooling off at the time of the killing. If the Commonwealth has not proved beyond a reasonable doubt the absence of heat of passion induced by sudden combat, the Commonwealth has not proved that the defendant committed the crime of murder. In summary, a killing that would otherwise be murder is reduced to the lesser offense of voluntary manslaughter if the defendant killed someone because of heat of passion on reasonable provocation or heat of passion induced by sudden combat. The Commonwealth has the burden of proving beyond a reasonable doubt that the defendant did not kill as a result of heat of passion on reasonable provocation or heat of passion induced by sudden combat. If the Commonwealth fails to meet this burden, the defendant is not guilty of murder, but you shall find the defendant guilty of voluntary manslaughter if the Commonwealth has proved the other requirements. 3. Excessive use of force in self-defense. As I have explained to you earlier, a person is not guilty of any crime if he acted in proper self-defense. The Commonwealth must prove beyond a reasonable doubt that the defendant did not act in the proper exercise of self-defense. If the Commonwealth fails to do so, then you must find the defendant not guilty, because an element of the crime that the Commonwealth must prove beyond a reasonable doubt is that the defendant did not act in the proper exercise of self-defense. In this case, you must consider whether the defendant used excessive force in defending himself. The term excessive force in self-defense means that, considering all the circumstances, the defendant used more force than was reasonably necessary to defend himself. In considering the reasonableness of any force used by the defendant, you may consider any factors you deem relevant to the reasonableness of the defendant's conduct under the circumstances, including evidence of the relative physical capabilities of the combatants, the number of persons who were involved on each side, the characteristics of any weapon used, the availability of room to maneuver, the manner in which the deadly force was used, the scope of the threat presented, or any other factor you deem relevant to the reasonableness of the defendant's conduct under the circumstances. I've already told you that to prove the defendant guilty of murder, the Commonwealth is required to prove beyond a reasonable doubt that the defendant did not act in the proper exercise of self-defense. If the Commonwealth proves the defendant did not act in proper self-defense solely because the defendant used more force than was reasonably necessary, then the Commonwealth has not proved that the defendant committed the crime of murder. But if the Commonwealth has proved the other required elements, we shall find the defendant guilty of voluntary manslaughter. If the evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense, you have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of any offense charged, you must find him not guilty. All right, so jurors, that concludes the first part of my instructions. What I'm going to ask you to do is you're going to leave your instructions on your chairs with your notebooks. Please do not take the instructions into the deliberation room with you at this time. And we'll come back at 2 o'clock. We'll hear the closing arguments, and then I'll give you the remainder of the instructions, and then I will send you out to begin your deliberations. Again, you are not yet deliberating, so please don't talk about the case at all.
All right, please.
All right, so he just went through jury instructions. So we heard we have first, second, and involuntary is on. Right? Was it involuntary or voluntary? I think it was. I have voluntary written down, but then I just heard him say involuntary. Please remind me, guys, was it voluntary or involuntary? All right, anyway. I'm going to go ahead and fast forward. And if you haven't taken the poll, please do so. As we look at that lonely only fan. The lonely only fan. Wow, this is a long break. This must be their lunch break. Okay.
Ready for the jurors? Okay. We're all set.
Yes, you're on your way.
All rise, please. Close the session, please. be seated.
All right, so jurors, we're going to go into closing arguments. I would ask that you put the instructions that I gave you, just put it under your seat and put your notebooks under your seat. Closing arguments are not evidence. And then when I resume the instructions, obviously you can take the instructions back out. Mr. Reddington?
Thank you. Members of the jury, thank you again for your attention. The time you took away from your family, your work, to sit here in a courtroom for a long time and listen to evidence. And when you think about the beauty of the jury system, is that a citizen, when they're charged with a crime, has the right to have a jury of their peers sit in judgment on the case. And you're all, people come from all walks of life, different jobs, different backgrounds, upbringings, and you have your common sense, you have your life experience that you bring to that jury room when you sit down and you deliberate the case, and you determine whether or not, consistent with your oath as jurors, that the government has proven the charge beyond a reasonable doubt. And you heard His Honor explain to you what beyond a reasonable doubt is. Often used, hard to explain. He did a pretty good job on it as far as explaining to you that close is not enough. More probable than not is not enough. They have to have proof beyond a reasonable doubt to the highest degree of certainty in lives of human beings. You heard His Honor indicate that the government, anytime the government charges somebody with a crime, the government has the burden to prove that person's guilt beyond a reasonable doubt, and that is up to the government. They determine what charges are going to be leveled against someone. They determine what the person is going to be charged with, and then you have, the judge will give the jury the elements, the building blocks of the case, what the jury considers as far as whether or not they've proven a particular charge beyond a reasonable doubt. And the burden of proof in this case lies squarely on the government, on the Norfolk County District Attorney's Office to prove to you beyond a reasonable doubt the allegations. Murder in the first degree, premeditated malice aforethought, cruelty and atrocity, the worst thing we ever reserve on cases. First degree murder, second degree murder, the intentional killing, taking of a life, knowing what someone is doing, having the ability to think, deliberate, plan. Whether or not they react, the government has to prove that this killing was not as a result of self-defense. They have to prove that it was not as a flow from a reaction to an assault that is the culmination of the plan. There's a plan here for sure. And the plan was on the part of Miss McLean to get that house, to get his money, and get him out. You can see a lot of these issues, you can see by evidence, not what someone says to you here in the courtroom, but what was in existence at the time. Text messages speak volumes because they show what's in someone's mind at the time that they send the text message. Photographs showing the scene is important because they show, for example, the shattered glass all over the bedroom floor in the front of the bed by the end board. The glass that's broken, that's up on the piece of furniture. The other glass that's broken, that's underneath the other piece of furniture. All of those items speak volumes as to what happened that night. That night, which was the culmination of the McLean plan, and again, you look to the texts and the evidence that was in existence. If he dies, do I get the house? If he dies, do I get the house? You saw that from the text twice that she sent to to Mr. Keighton about the deed. Get on the house, get on the property, you own it. If he dies, you get it. Height of the pandemic, get out. You heard, get out. Get out, go walk to your hotel. Leave the car's mine. No, it's not. Well, the judge says it is, as is the house. This is all about money. All about money. And she played him pretty darn good. Smart guy, obviously, in an operating room. Not a smart guy when it comes to real life. You heard the background, you heard his life story, you heard he learned English, taught himself English, rose to the pinnacle of his profession, specialized for a while dealing with pediatric oncology surgery, robotic surgery, all of that, wonderful. Doesn't mean anything, it's ashes blown in the wind. Because he had the pleasure of meeting Kate McLean on Bumble. And they went out on a date. A lot of people do. Many people get together as a result of that. God bless them, that's awesome. If they have a good relationship, wonderful. You think about it. He's living life large. He's got his Harley Davidsons. He's got his house. He's got his job. He's got his money. He can go out on dates. He can stay at home. He can go do whatever he wants to do. 2 years. 2 years they live together. She comes in with her 3 children after a number of weeks, brings the 3 children into his house, welcomes them in. They live together for 2 apparently uneventful years. He's paying the bills, taking care of the house. She's got the 3 kids there. You heard evidence that during that period of time, Mr. Rocca, so the man with the beard, father, he's trying to visit with his kids. Couldn't visit with his kids. Had to park his car out in the street. You heard all that. This is Katie McLean. Katie McLean's life. Then, all of a sudden, she applies for a wedding license or whatever, marriage license. Applies for the marriage license. Gets the marriage license. He's going out to Las Vegas to do a thing. We're talking about elderly medicine at the Bellagio. And he takes her along. Next thing you know, they're going through, and again, I don't have to hold up pictures, and I don't have to have visual aids. You're sitting, you're intelligent people, you sat here through this trial, you know what the photographs show, you know what evidence has been presented to you, you know that they went through the Elvis drive-thru. Who does Elvis drive-thru wedding? Well, hallelujah, we're married now. 5 weeks. 5 weeks. And then he reaches out to an attorney and says to the attorney, look, I want a divorce or an annulment. One or the other. I don't care. I want out of this. 5 weeks. She goes on his phone. You get evidence. She goes on his phone. She checks his phone. She's looking for girlfriends, texting. What are you doing? Who are you doing it with? Let me see it. Give it to me. And she sees that deadly email from the attorney, Mary LaCivita. And do the math. It's a day or so later that she gets her bogus restraining order. Throws him out of his own house. He's now out. You heard the officer testify. He was a gentleman. He wasn't some crazy ranting person, angry, upset. Had his hands on his knees. He's like hyperventilating. Please, do we have to do this? What do you mean? I'm out of my... You gotta go. Okay, Katie McLean says, gotta go, you gotta go. Now, she stays in that house. She has a place in Belmont, her mother's condo in Belmont. She could have gone there. No, she likes Dover. She loved Dover. The kids loved Dover. Because Harry went, because they wanted. They have entertainment. Harry builds the theater. He builds the swimming pool. You heard about the waterfalls and the TVs and the entertainment thing because she liked to entertain. He didn't say that like, oh, she liked to entertain. He said just like, Katie loved to entertain. He had an affinity. He had a respect for her. He had a love for her. He wanted her to be happy. He built all these things in the house to make everybody happy. What everybody? No problem. Take care of everybody. Not a problem. Well, once the passage of time, goes by. Into, what is it, February of 20, he's with Charlie Lax. Friend who allowed him to come in, no problem. After that, he ends up for a period of time with Richie Kovitz. You saw Richie Kovitz, nice guy, testified, had to go to Florida, he lives in Florida. He let Harry come in to his condo with his girlfriend, fiance, Carla, for months. Harry stayed there for months. Pandemic hit, we all know that, we all lived it, we all know how horrible. Many times people were drinking wine at 11 o'clock in the morning. You don't know if you're going to die the next day, you don't know. When in supermarkets, you get arrows telling you, go this way, go that way. Wear masks, can't eat, can't go to a restaurant. He, meanwhile, doesn't have what did the police officers say, shelter in place. He doesn't have a shelter in place. Because now, after he went to Germany, again, he has his life back on track. He's got a job in Germany with robotic surgery. Katie McLean and her 3 kids are in the rear view mirror. He's moving on. He's getting a divorce. He's moving to Germany. And he's going to have a darn good job working at that hospital. Not to happen. Because at the height of the pandemic, he has to come back. He's back because of the presidential decree. Comes back to Massachusetts. What's he going to do? Goes to a hotel. Okay, fairly expensive. If you recall, maybe you have life experience during that period. You can't do anything in a hotel. You can't eat. You can't go to a restaurant. You can't do anything. So he's living in a hotel. He's communicating as time goes by with friends or family, and during that period of time, he ends up with Kurt Vandensteel. Good old Kurt. His best friend. Kurt backed up on that like a poodle on a linoleum floor when I asked him, you're his best friend? No, well, no, I'm not his best friend. I mean, yeah, I know the guy. I was friendly with Katie. I guess you were. Do you really think that Kate McLean had the intent to take this guy back into her life? Do you really think that Kate McLean wanted to have this old man back in her life and she loved him? She has her goals. She reaches out to him. You heard the government jump up and down and ask him, because he won't. You're the one that wanted to reconcile. Katie McLean has just had many friends. Wonderful, wonderful woman. You wanted to reconcile with her. And I suggest to you that his testimony was consistent because it's the truth. And he testified and told you under oath that it was Kurt Vandensteel that reached out to him initially on a FaceTime call with Katie McLean. Come back. Now, meanwhile, he's in Florida, right? He's living in a trailer in Florida. How the mighty tumble. He's living in a trailer. Got to get out of the trailer. You can't fall much lower than that when you got to get out of the trailer. So he's got to leave the trailer, and now he's got his problem with his hip and his back, and he's got to come back up to Massachusetts. Well, Kurt comes to the rescue with that call. I love you. I want you back. He now sees a light at the end of the dismal tunnel. And during that period of time, he is able to make arrangements to meet Ms. McLean in New York, drive back. She's got Mr. Roca with her. He told you he was shocked, surprised, because that was the last guy in the world that he expected to see her with. You heard evidence that during this period of time that she had people in the house, and she's certainly not entertaining her friends. During this period of time, he's thinking that they're going to reconcile, but right up to the very end of that period of time, she's not in a mindset that she wants to reconcile. She's more interested in talking to guys and doing whatever she's doing with Kurt, and you heard the evidence. What do you think was in her mind? You think she really wanted to reconcile? No, she wanted the deed. She wanted the house. She wanted the security. We can say security. She wanted the security. This fool signs a deed against his lawyer's advice. He says to him, don't sign the deed. Don't sign the post-nup. What are you, nuts? There is no basis for alimony of a 5-week marriage. You've been played. But he signs the deed. He signs the post-nup. makes arrangements to meet with her. Now, he then is living in that hotel that we saw that little room. There's a restraining order. She drops a restraining order. Of course, it's part of the plan. Drop a restraining order. She didn't care if he was in the house. Come on, come in the house. Let's go, in the house. You're able to go in the house. He brings his little ditty bag, goes in the bedroom. Beautiful, everything's great. We're going to live together. Things are going to be great. We're going to reconcile. Didn't know about Kurt, didn't know about the text, didn't know about that state of mind. During that period of time, they end up. And it's not easy to talk about people. I mean, the woman is dead. As an attorney, I'm not stupid. I know you don't, as we say, trash the victim. I know that. But it's the facts of the case. And if I was arrogant or obnoxious or I was hard on a witness, don't hold it against him. Because that was my cross-examination. But in my opinion, I did what I believed that had to be done to show you what the truth is and was at that time. So he's now in the house with her. He said that it was sex. Said that at his age, it was a little overbearing, but nevertheless rose, so to speak, to the occasion. During that period of time, I had texts that showed it's 11:45. Let's fuck. Come home. And whatever she said, with your wife. Do this with your wife. And interestingly enough, the round spot of blood on the bed that is hers. Yes, you have a text where she indicated on May 6th that in fact she's telling him I'm on my period, so you can't have sex. We're talking a week later. They had sex. You heard the DNA the person talk? Yeah, that was her DNA. And 3 other contributors. My God, 3 other contributors. YSTR profile, male profile, in that spot, in his bed, in his bedroom. In any event, they have sex. He told you that night they had sex. You heard the DNA woman say, yes, if a guy is married to a woman or a guy and a girlfriend or whatever, and they're intimate with each other, yeah, of course there's going to be DNA in their hands or under their fingernails. This is not blood. This is not skin cells. It's touch or handler DNA from touching someone, rubbing someone's back, clawing someone's grab, grabbing their butt, grabbing their junk, grabbing whatever you grab, however you grab it, you're going to get DNA on your husband or wife's hands. But they run with that. That and the blood spot on the bed. Oh, you saw and heard. There's not one whit of evidence that she had a bruise about her face, her head at all. No evidence whatsoever of any bruising in the area of her face and head. Of course, we have the government's pathologist who testified, and it's your memory, not mine. Very nice woman. Testified as best she could. She's probably overworked, had a lot of files, a lot of cases. And I suggest to you that she couldn't remember basic things from that autopsy. That's fine. She says, oh, there's subdural hematoma in the back of the head and the side of the head. Initially, is there any bruising? No. And then it was, well, subdural hematoma. Yeah, that could be bruising. Yeah, okay. Well, you heard Dr. LaPosada indicate that that is from the person being, for a period of significant time, prone over the water. And when we talk about the water, that is what is called post-homicide conduct. What's at play with a jury is what was in the person's mind at the time of the killing, not what occurs afterwards. Granted, you heard him testify. He's not proud of that fact. He lives with it, but it has nothing to do with what was his state of mind at the time she smashed the glass, which you believe obviously happened, off of his head. You saw the photographs. You saw it's almost an inch above the hairline of the cut. He indicates that he is holding his hand and reacts with one hand. You heard Dr. Lapasada's testimony. There is no bruising about the head or the face. There's no bruising anywhere, actually, other than the neck. Bilateral, not circumferential, not grabbing with two hands. Dr. Lapasada clearly and unequivocally states bilateral grab from a very, very powerful man with huge hands, okay? Bilateral grab. Reacting. Both of them drunk. She dies. He knows. Is that premeditated? Is that cruelty and atrocity? A matter of seconds, Dr. Lapasada stated. Seconds. I suggest to you that he reacted. He was drunk. He reacted to the assault. He defended himself. He did not use excessive force. He reacted to stop the assault. Any one of you or anybody is entitled to defend themselves. And the beauty of the law is that the government has to prove beyond a reasonable doubt that he did not act in self-defense. They have to prove. How can anyone say he did not act in self-defense? That's a not guilty. He acted in self-defense. The circumstances attending that set of events that occurred, the government has to prove to you beyond a reasonable doubt he did not act in self-defense. The government suggests that, this is first-degree murder. Second-degree murder, when you look at the facts of the case, consistent with the instructions his Honor gave you, is this a killing that occurred in hot blood, heat of passion, on sudden, adequate provocation? Isn't that all over the place? They have a burden to prove to you beyond a reasonable doubt that he did not act on reasonable provocation, did not act in a heat of passion, did not act because of the emotion of the assault, did not have the ability to form intent at the time. There's no intent to kill. There's an intent for self-preservation. You heard Dr. Zeisel talk about fight or flight. You heard Dr. Zeisel talk as a psychologist about pretty fairly standard psychological principles that all of us have. That little hypothalamus or whatever it is, that thing in your brain, tunnel vision, you do stupid things afterwards, you try, it's because you're nervous. It's the overwhelming fear, the overwhelming fright that eclipses your ability to think straight. That's what the pond is about. The pond has nothing to do with the circumstances of the killing. The killing occurred. She smashed the glass. After she told him to get the F out, get out of my house, and the deed was recorded that day. And he moved in that night, that day. One night. The evidence shows shattered glass. Do we have it? No. Where is it? Who knows? Probably a dump somewhere. Is that important to have a full, fair investigation? You heard, and the cops, you can wind them up and they'll walk up to the witness stand and you can press the button and they'll testify and they'll give the right answers. But does anyone really think Kotkowski knew what the hell he was doing here? Testifying? He didn't even know where the argument took place. He stood up there and told you, I don't know. It's possible. It's possible it took place in the bedroom. Come on. Was there glass on the floor? I think I recall. What do you mean you think you recall? You're a chief homicide investigator on a murder case. Man's life is at stake, and you think, you recall, because you get your check on a Friday? That is a lousy police investigation. And you know what? You know what? The other young man that came in and said, well, if it had red marks on it, I would have examined it. And I said to him, you have to know it's there before you can examine it, right? He didn't even know that there was a second glass. When the police investigate, as citizens, we expect they're going to have an open mind, they're going to do a good job, they're going to seize evidence, they're going to secure things, and they're going to do the best they can to be able to prove a case to a jury beyond a reasonable doubt. Didn't happen in this case. It was a foregone conclusion. But they knew nothing about text messages, did they? They knew nothing about the goings on between the two of them. They knew nothing about the deed. They knew nothing about the post-nuptial agreement and the money that's paid. They knew nothing about the destruction that she rained down on this man's life. This is not a murder. You bring your common sense, you bring your life experience to that jury room, you look at all this evidence, you look at the time frames, you look at the deed, you look at the photographs, you look at the medical records. The medical records have the guy at 226 blood alcohol 19. You see the comment in there, suicide by alcohol. And you can make fun of the fact, oh, well, you know, it's superficial scratch. Anytime there's marks and cuts on somebody trying to kill themselves by not going sideways, linear lines, they're superficial. Post-contact, you can say that's superficial. He wanted to kill himself. He wanted to say goodbye to his friends. He wanted to say, I love you to some people. He did that with Kurt and some of the other people that he sent messages to. She played us. She was the devil. I love you, Harry. This is the end of a tragic human story. But I suggest to you, members of the jury, that when you consider Judge Hallal's instructions, ever mindful of the burden of proof, this man is not guilty of murder. Thank you.
Thank you, Mr. Reddington. Ms. McLaughlin?
On May 15th, 2020, Katie McLean took her last breath with the defendant's hands wrapped around her neck, squeezing the life out of her. He took her lifeless body past her children's bedrooms, down the stairs, placed her into the car, and drove her to a home that she and the defendant had once looked at to buy for their family. He took her body through a dark wooded area with thick brush and trees and placed 2 large rocks in her leggings, and then he discarded her in that pond like a piece of trash. During the course of this trial, you have heard that Katie was married to Stephen Rocca and had 3 children with him. After that marriage ended, she was briefly married to a man named Chris Foley. And then in November 2017, she and the defendant met online and began their relationship. You heard that sometime in 2018, Katie and her 3 children moved into 29 Valley Road with the defendant, and her children began attending school in Dover. In December of 2019, Katie and the defendant were married in Las Vegas, but the relationship deteriorated. And by early February 2020, Katie had obtained a restraining order against the defendant, who was no longer living at 29 Valley Road. The pandemic hit about a month and a half later, and the world shut down. The defendant made his way to Florida and planned to sell the house at 29 Valley Road. Both he and Katie were moving forward with the divorce. However, on April 17th of 2020, that all changed when the defendant reached out through his lawyer, John Hoffman, and requested Katie consider a reconciliation. You heard testimony from Vanessa Pettigrew and Stephen Rocca that show Katie wasn't wasn't sure about the reconciliation, but she wanted to try to make her marriage work because she loved the defendant and she wanted stability for her children. So Katie and the defendant worked out an agreement to try to help Katie feel secure in their relationship, which included signing the deed on April 29th of 2020 to give Katie half ownership in the house, and the two also established a post-nup agreement. You heard on May 8th of 2020, Stephen Rocca drove Katie to New York to meet the defendant, and she and the defendant drove back to Massachusetts together. You saw surveillance video and the reservation receipt from the Marriott showing the defendant check in on May 8th with the intention of staying at the hotel until May 17th. But on May 15th, 2020, that hope of reconciliation came to an end when the defendant killed Katie in their bedroom at 29 Valley Road. And for that, the defendant is charged with first-degree murder. The defense suggests that the defendant killed Katie in the heat of passion or in self-defense. He was under extreme stress from the pandemic, had just placed her name on the deed of the house, and snapped that night when she threatened to make him leave again. He also suggests that because Katie had texted with friends about her relationship with her husband, and because she wanted stability for her children, that she just wanted his house and his money, and never really wanted to reconcile. And that, coupled with the fear of being kicked out of his own home during the pandemic, is what led him to snap. Ladies and gentlemen, I suggest that is not heat of passion. It is not self-defense. It is motive to kill. And the defendant's text to Kurt Vandensteel after the murder is further evidence that the defendant did not snap and kill Katie and then instantly regret it like he wants you to believe. That text shows his constant and enduring belief that Katie was a vindictive devil, and it shows his motive to kill her, to get rid of her so that he would not have to go through another divorce and he would not lose his house again. I want to remind you about the defendant's statement on May 16th of 2020. It was 1 hour and 20 minutes into that interview when the police first suggested that Katie had hit the defendant. Sergeant Kakowski continues to suggest that Katie hit the defendant with something. He tells the defendant about the broken glass in the bedroom and points out the small abrasion on the defendant's head. It is not until then that the defendant adopts Sergeant Kakowski's statement that Katie had hit him. I would suggest to you that the defendant adopted this theory to minimize his culpability as he was confessing to killing Katie. A killing that was driven by greed. As we heard numerous times throughout this trial, it was his house and it was his money, and he was not going to give those things up. In those moments, the defendant was not overcome with emotion or fear or panic. He was angry, and he wanted to make sure that Katie was not going to get his house. And the only way that would happen now that the deed was signed was if she was dead, and so he killed her. I would suggest to you that all of the evidence you have seen and heard throughout this trial shows that the defendant not only had the motive and intent to kill Katie, but he also had the opportunity when he got himself back into that house. I would point you to the evidence in the bedroom, the shattered glass all over the floor, Katie's blood on that bed in 2 different spots. The photographs of the scrape on the defendant's head, coupled with his medical records that documented it simply as an abrasion. The lack of red-brown stains on any piece of glass that was photographed in that bedroom, and the small cuts on the defendant's hands by his thumb and index fingers, with the evidence of the defendant's DNA under Katie's fingernails. This evidence is not consistent with a single blow from a glass and a quick grab to the neck that caused death. I would suggest to you what this evidence is consistent with is a violent struggle. A violent struggle as Katie fought for her life in that bedroom. And the extensive injuries to Katie's head and neck described by Dr. Matthews are just further evidence of that violent struggle for Katie's life that occurred inside that bedroom on May 15th. Now I want to talk to you about what some of the defense witnesses said. Think about Attorney Hoffman's testimony and the series of emails sent by the defendant on April 10th, on April 13th, and April 15th. He was still committed to that divorce, and he wanted back in that house. And he wanted Katie and her 3 children to move to Belmont. And then 2 days later, he suddenly had a change of heart and wanted to reconcile. He wanted to make Katie and the kids feel secure. So he put her name on the deed, which meant that she was entitled to half the house if they were to get divorced. But also remember that becoming tenants in common on a deed means if one of them dies, the other one gets the house. Dr. Laposadas testified that Katie's death was a result of a one-handed application of force. I would ask that you remember this is a doctor who has not examined a body in over 20 years. Her demeanor appeared aggressive and argumentative as she was testifying. And I would suggest, as a paid defense expert, she had an agenda. And she wouldn't even answer the simplest question on cross-examination without pushing that agenda. Dr. Laposada also made sure to emphasize all the things that she did do as she considered the cause of death and the circumstances surrounding Katie's death. But there are 2 things that she did not do. She did not examine Katie's body, and she did not listen to the defendant's statement to police from May 16th of 2020. The statements in which he said, "I choked her. I grabbed her around the neck, and she was fighting, and I continued, and then she passed out." The defense suggests that this was an impulsive knee-jerk reaction. Dr. Zeisel testified that people in highly dangerous situations can have a fight or flight response and can act without thinking. He gave examples of hurricanes, mass shootings, and being attacked. But he also agreed in those situations, you do not lose your free will, and you do not lose the ability to make a choice. The defendant, who I suggest appeared methodical and detail-oriented, testified that he was down on his knees, begging Katie to stop as she was yelling at him and then hit him with a glass. He testified that he snapped and blacked out. But he did remember that he grabbed her by one hand on the neck. He described her flailing, and then they both fell to the ground, and he told you that when he came out of his blacked out state, he saw she was non-responsive. So he put her on the bed and started CPR. But it didn't work. I would remind you that in his original statement to the police on May 16th, 2020, he did not tell them he was on his knees. He did not tell them that he only grabbed her with one hand, and he did not tell them that he tried to perform CPR. In his testimony yesterday, he also told you that he panicked and wanted to move Katie's body so that her children would not find her. I would suggest that the defendant took the methodical and detail-oriented steps to dispose of Katie's body in an effort to save himself, not her children. At times during this trial, the defense has also tried to disparage, embarrass, and blame Katie. But I would suggest that is not what this case is about. And it was meant to distract you from the focus of this trial, which is the death of Katie McLean. Earlier, Judge Halal instructed you on the elements that the Commonwealth must prove beyond a reasonable doubt in order for you to find the defendant guilty of first-degree murder. He explained that there are 2 different theories by which the Commonwealth can prove first-degree murder. The first is deliberate premeditation, and the second is extreme atrocity and cruelty. I submit to you that the Commonwealth has proven both theories beyond a reasonable doubt. When considering the first theory, deliberate premeditation, the first element under this theory, it's not contested. The defendant admitted in his interview that he killed Katie McLean by strangling her. He told you in this courtroom that he killed Katie. And Dr. Matthews, the medical examiner, testified that Katie's cause of death was strangulation. The second element is that the defendant intended to kill Katie. The defense suggests that the defendant did not form the necessary intent to kill Katie, and they point to his intoxication and also argue that he killed her in the heat of passion or in self-defense. When thinking about this, I want you to think about the defendant's own words in his interview to the police. You always have a choice. And I would suggest to you that the defendant made a choice in the early morning hours of May 15th to kill Katie. Think about his other statements during that interview. She was fighting and I continued. Then she passed out. He had a choice to stop as she was fighting, and he did not. In those moments, he made the choice to keep going and to kill Katie. And I suggest to you that is intent. Attorney Reddington suggests that the defendant was intoxicated and snapped and could not control his conduct. When considering whether the defendant's drinking that night played a role in his behavior, think about the meticulous steps that he took after she was dead. He carried Katie's body down the long staircase at 29 Valley Road. He placed her into her vehicle and drove her to a pond that he had been to before. He walked in the dark through thick brush and trees, causing the scratches and abrasions to his head, to his legs, and his arms. Then he placed 2 large rocks in her pants to weigh her down, to hold her body down. Then he started driving to Dedham, but realized that he had forgotten his phone, so he went back to the house. He got his wallet, he got his phone, he changed his clothes, he locked the bedroom door. He drove those windy, dark, country roads from Dover to Dedham, without crashing, without getting pulled over, and then he parked within his parking spot. He put on his mask. He removed his wallet from his pants. He swiped his card around 5:30 a.m. to enter that building. He walked past the reservation desk, through the lobby, and up to his 2nd floor room. Not stumbling, not falling down, not incapacitated. I would suggest he is quite the opposite. He is cool, he is calm, and he is collected. His clothes and his hair are neat and orderly. And again, look at that coherent text he sent to Kurt about his hatred for Katie. This text does not show panic. It does not show remorse. It shows motive, and it shows intent. I would suggest to you that the defendant's behavior directly after the crime does not indicate that he was in a fit of rage or so intoxicated at the time he killed Katie. I would suggest to you it's the behavior of someone who is in complete control of himself. He is aware of his actions and the potential consequences, and he took well thought out, methodical steps to dispose of her body and cover his tracks. Also remember, the defendant was alone in that hotel room for 5 hours with a large bottle of alcohol that was half empty when the police entered at 10:50 a.m. During that time, when he was alone in the room, he had time to think, he had time to reflect, and he had time to plan. Likewise, the defense wants you to believe that the defendant wants you to believe that he was either intoxicated at the time of his interview or was feeling the effects of his prior intoxication. He wants you to believe he was confused, he had memory lapses, and he didn't understand what he was saying because of his blood alcohol level when he was admitted to the hospital. I would ask that you use your common sense and your life experience when evaluating these statements. The Dedham police arrived at the hotel around 10:50 a.m. on May 15th and found the defendant, who was immediately transported to the hospital. His lab results from noon on May 15th show his blood alcohol level to be elevated. But remember, the interview with the police did not begin until 5:19 p.m. on May 16th, almost 30 hours later. Remember the testimony of Ailish Wilkie, who told you it was her job to protect the defendant, and she would not have let him talk to the police if he was unable to or if he was unwilling to. Think about the defendant's behavior in that interview, how clear his voice was while even wearing a mask, how he was able to spell everyone's last name correctly without being asked. Think about the testimony of Detective Gonski and Sergeant Kakowski that the defendant walked in and out of that room unassisted. He sat up in a chair throughout the entire interview, and he was calm and coherent throughout that entire interview. All of these details, coupled with the police being calm and patient and allowing the defendant the time he needed, point to the defendant's statement being knowing, voluntary, and intelligent. The third element, whether the defendant decided to kill Katie after a period of reflection, Judge Halal instructed you that that period of reflection can be just a few seconds or minutes. I would suggest to you that the defendant's words to the police on May 16th, that Katie fought and he continued, paired with the small cuts around his thumb and his index finger and his DNA found under Katie's fingernails, indicate she was fighting him. And I would suggest it shows that he knew exactly what he was doing when he continued to strangle her as she was fighting for her life. The defendant's own words indicate he had time to reflect about his actions and those consequences. She was fighting and he kept going until she was dead. Also think about the fact that the defendant is a renowned surgeon. We heard a lot about that through this trial. He is trained to react under pressure. He has training on the human anatomy. But, as he said in his original statement to the police, he admitted he did not try to resuscitate Katie, and he did not call 911. Instead, he removed her body from the house. He weighed her down with 2 large rocks, and he sunk her body in a murky pond. Ladies and gentlemen, I would submit to you that all of that is deliberate premeditation. The second theory of first-degree murder that you must consider is extreme atrocity and cruelty. As with deliberate premeditation, we know the defendant killed Katie. And when considering the second element, his intent, again, remember the defendant has substantial medical training as a doctor. I would suggest that any reasonable person would know that cutting off someone's air or blood supply could result in death. The defendant, with his significant medical training, would have known that wrapping his hands around Katie's neck and continuing to squeeze as she was fighting him would reasonably cause her death. And during his testimony, he acknowledged that. The third element, that the killing was done with extreme atrocity and cruelty. When thinking about this element, I want you to remember the defendant's statements during his interview, as well as Dr. Matthews' testimony. I would suggest that the defendant continued to strangle Katie while she was fighting shows his indifference to her suffering. Think about the testimony of Dr. Matthews and the extensive injuries that she detailed, the petechia in Katie's eyes, the external injuries to her neck, the internal injuries to her head and her neck, and her broken hyoid bone. Remember where Dr. Matthews said the hyoid bone was, placed within the neck muscles, and the fact that Katie's hyoid bone was fractured. And the hemorrhages in her neck were 4 layers deep. Dr. Matthews agreed that it would take significant force for those injuries to occur, and that all of Katie's injuries occurred before her death. That, coupled with the injuries to the defendant's hands and his DNA underneath her fingernails, shows that she was conscious and suffering as the defendant was squeezing the life out of her. I would suggest to you that all of this evidence shows beyond a reasonable doubt that Katie's death was completed with extreme atrocity and cruelty. Ladies and gentlemen, you were instructed at the beginning of this trial and again at the end of this trial on the meaning of reasonable doubt. You have heard that the evidence must convince you of the defendant's guilt to a reasonable and moral certainty. A certainty that convinces your understanding and satisfies your reason and judgment. As you consider how the Commonwealth has convinced you of the defendant's guilt as to first-degree murder to a reasonable and moral certainty, I'd ask that you remember the layers of injuries to Katie's neck, her broken hyoid bone, the fact that the defendant was a doctor with extensive medical experience, and he knew that strangling Katie would reasonably result in her death. The statements to law enforcement that he made, you always have a choice. The 2 large rocks that he placed within her pants before dumping her half-naked body in that pond. The text he sent to Kurt after he had killed her and disposed of her body. That, members of the jury, is proof beyond a reasonable doubt. I'd ask that you consider all of the evidence and return with a verdict finding the defendant guilty of first-degree murder. Thank you.
Thank you. Jurors, why don't you stand up for a minute if you want to stretch before I finish the instructions. So we left off on page 33. All right, and the heading is no transcripts. So although our court reporter recorded everything in court during the course of the trial, we do not have written transcripts of any portions of the trial testimony that we can give you for use in your deliberations. You must therefore use and rely on your own collective memories of the evidence, assisted perhaps by your notes. Now, since determining the facts in this case is your duty and not mine, you are to draw no inferences, favorable or unfavorable, to any party because of anything that I, as the judge, may have said or done during the trial of this case. If somehow you think that during the course of the trial I made certain rulings that suggested how I felt the case was going in, or how any issue of fact should be resolved, or how you should find the facts, then you are to ignore it. Because this decision that you must make on what the facts are in this case must be made free from interference from anyone, including me. My role as the judge is to see that there is a fair, orderly, and efficient trial of this case. My role is also to rule on questions of evidence and matters of law, and to instruct you on the law as I am doing now. Your role in this case is the most important role in this trial, because you and you alone will determine what the facts are. In a sense, you are judges when you do that. You are the sole judges of the facts. Now, in deciding what the facts are, you all have certain tools available to you. The primary ones are your own common sense, good judgment, and general life experiences. Now, if in the course of opening statements or closing arguments or during the trial itself, the attorneys or even I as the judge call to your attention matters of evidence that you do not remember collectively as a jury, then you are free to ignore it, because it is your memory of what the testimony was and what the evidence is that controls your deliberations in this case. You alone will determine the weight and the effect and the value of the evidence and the believability of the witnesses. Once you make those determinations of fact, it is then your duty to apply them to the law as I now give it to you. In deciding whether the defendant is guilty or not guilty of the charges that have been brought against him, you must act without prejudice, without fear or favor, and make your judgment solely from a fair consideration of all of the evidence. Emotion or sympathy for one side or the other has no place in your deliberations, and you are not to decide this case on the basis of what you may have learned or heard outside of this courtroom. You may not speculate as to what might be or might not have been the facts, and you must not be influenced by the popularity or lack of popularity of the crimes that have been charged. Rather, you must confine your consideration to the evidence and nothing but the evidence, and your decision must be based on common sense, good reasoning, and good judgment. Your decision must be made without partiality and without concern for the effects or the consequences of that decision. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, immigration status, language, religion, age, ability, gender, sexual orientation, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we are not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. We judges have the same problems, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all of the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you're actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions. So don't be shy or hesitate to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you'll do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. Let me talk about the respective roles of the assistant district attorneys and defense counsel. It is their role to present evidence in this case that is most helpful to their respective positions. It is also their duty to object when evidence is offered that they believe may be inadmissible under our rules of evidence. And the way those matters have been handled, as you've observed, is that I've either ruled on the objection from the bench and the case has proceeded, or we've had a discussion at the side of the bench, outside of your hearing, where I have addressed the matter of law at issue, made a decision, and the case has proceeded. Any such activity on the part of the assistant district attorneys or the defense attorney in this case in making an objection or requesting a sidebar conference is not to be held against either the Commonwealth or the defendant in your consideration of the evidence or in your deliberation of your verdict. Now let me tell you what is evidence and what is not evidence in this case. Evidence is what you've heard from the witnesses who have testified here in court before you under oath and given answers to questions put to them by the assistant district attorneys and defense counsel. You've had a chance to listen to each witness, to observe each witness, to consider all of what he or she has said and how they've said it, and that is evidence. The quality or strength of the proof is not determined by the sheer volume of evidence or by the number of witnesses that have been presented at trial. Rather, it is the weight of the evidence, that is, its strength in proving or disproving the issues at stake, that is important. You should consider all of the facts and circumstances and evidence and all of the witnesses that have been presented during the trial in determining whether the Commonwealth has proved each of the elements of the crime charged against the defendant in this case beyond a reasonable doubt. Now, some things that have occurred during the course of this trial are not evidence, and you may not consider these things in deciding the facts of this case. As I've already told you, the indictment in this case is not evidence. The fact that the defendant has been arrested or charged in this case is absolutely not evidence with respect to his guilt or innocence. A question put to a witness by an assistant district attorney or defense counsel, no matter how artfully phrased, is not evidence and is not to be considered by you unless and until the witness answers or adopts that question. Only the answers given by each witness are evidence. Also, you may not consider as evidence any questions, answers, or other matter that I've ordered stricken from the record and told you to disregard during the trial. You may not consider any item that was only marked for identification but never received in evidence at trial. The opening statements and closing arguments of counsel are important and helpful and appropriate, but they are not evidence in this case. The view is also not evidence in this case. Again, the view may have been important and helpful, but it is not evidence in this case. The personal beliefs of the court or counsel on any issue in this case or on what the evidence is not evidence. My instructions to you on the law and anything that it might have said to you in passing during the course of this trial is not evidence. Don't make up your minds about what the verdict should be until after you've retired to the jury room to decide this case and you and your fellow jurors have discussed all of the evidence thoroughly, thoughtfully, and carefully. Now, in the trial of this or any other case, there are two kinds of evidence, direct and circumstantial evidence. Direct evidence is proof of a fact, such as the testimony of an eyewitness, that is, someone who comes into the courtroom to tell you what he or she heard, saw, or felt. Generally, such testimony is based on the witness's 5 senses. Circumstantial evidence is proof of a chain of circumstances from which you may infer or conclude that a fact exists, even though it has not been proven directly. An inference is a permissible deduction that you may make from the evidence that you've accepted as believable. Inferences are things you do every day, little steps in reasoning in which you take some known information, apply your experience in life to it, and then draw a conclusion. You may draw an inference even if it is not necessary or inescapable, so long as it is reasonable and warranted by the evidence, and all the evidence and reasonable inferences in this case together prove the defendant's guilt beyond a reasonable doubt. Let me give you an example of an inference. If your mailbox was empty when you left home this morning, and you find mail in it when you get home tonight, you may infer that the mailman delivered the mail. Now, obviously, you didn't see the mailman deliver the mail, but from the fact that it was empty this morning and it is filled tonight, you can properly infer that the mailman came in the interim and delivered the mail. This is all that we mean by an inference. Whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant guilty beyond a reasonable doubt from all of the evidence in the case. Where the Commonwealth's case is based solely on circumstantial evidence, and that is for you to say, you may find the defendant guilty only if those circumstances are conclusive enough to leave you with a moral certainty that the defendant is guilty and that there is no other reasonable explanation of the facts as proven. Now, as I've said, your function, among others, is to decide the credibility of the witnesses. In determining the credibility and the weight to be given to the testimony of each witness, you should consider such factors as the conduct and demeanor of the witness while testifying, the frankness or lack of frankness of that witness, the reasonableness or unreasonableness of the witness's testimony, the probability or improbability of that testimony, the opportunity or lack thereof to see or to know the facts concerning that to which the witness has testified, and the accuracy of the witness's memory as well as the degree of intelligence shown by the witness. You may also consider the witness's motive to testify for or against either party, and of course, the interest or lack of interest of the witness in the outcome of the case. You may also take into consideration the age and the character and the appearance of each witness at trial, as well as any bias that he or she may have shown in their testimony in determining the credit to be given to that testimony. In evaluating the evidence presented by a witness, you as jurors are free to believe everything that the witness says, some of what the witness says, or none of what the witness says. If there are any conflicts in the testimony, it is your function to resolve those conflicts and to determine where the truth lies. There is one more point about witnesses to address: expert witnesses. This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge. That is, things that they have personally seen or heard or felt. However, in a variety of cases, issues arise that are beyond the experience of lay persons, and in those types of cases, we allow a person with specialized training or experience, called an expert witness, to testify, and to testify not only to facts, but also to opinions and the reasons for his or her opinions on issues that are within the witness's field of expertise and are relevant and material to the case. Because a particular witness has specialized training and experience in his or her field, does not put that witness on a higher level than any other witness, and you are to treat the so-called expert witness just like you would treat any other witness. In other words, as with any other witness, it is completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It is also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You are free to reject the testimony and opinion of such a witness in whole or in part if you determine that the witness's opinion is not based on sufficient education and experience, or that the testimony of the witness was motivated by some bias or interest in the case. You must also, as has been explained, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and opinion of the expert in whole or in part. You must remember that expert witnesses do not decide cases, juries do. In the last analysis, an expert witness is like any other witness in the sense that you alone make the judgment about how much credibility and weight you give to the expert's testimony and what conclusions you draw from that testimony. Next, I'm going to instruct you with respect to matters that may have occurred or arisen during the trial, and generally about the evidence and what you may do with the evidence that you've heard in this case. The Commonwealth has introduced into evidence certain photographs showing Kathleen McLean. You will have those photographs with you during deliberations in connection with the testimony you've heard. The photographs are not pleasant. Indeed, they may be described as graphic. I instruct you that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned from the photographs. Consider those photographs only as they may draw attention to a clinical medical status or to the nature of Kathleen McLean's injuries or to the nature of the incident itself. Now, you've heard testimony about statements by way of text messages and otherwise made by the decedent, Kathleen McLean. Those statements are to be considered by you for a limited purpose, that is, to show the state of mind of Kathleen McLean about her relationship with the defendant. You may only consider these statements as to Kathleen McLean's state of mind of the status of the relationship if you find that the defendant was aware of Kathleen McLean's state of mind regarding the relationship and only for the limited purpose of showing the defendant's motive. You may not consider any of Kathleen McLean's statements for the truth of the matters asserted in those statements. Now, you've heard testimony about a recorded statement allegedly made by the defendant concerning the offense which is charged in this case. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not. You may not consider any such statement in your deliberations unless, from all of the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that he is alleged to have made and that he made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may take into account the nature and duration of any conversations that the police officers had with the defendant. You may consider where and when the statement was made. You may consider any evidence you've heard about the defendant's physical and mental condition, his intelligence, age, education, and experience. If there is evidence that the defendant was under the influence of alcohol, you must take special care in determining whether any statement was the product of the defendant's rational intellect and free will. It is not enough that the statement was voluntary in the sense that it was not forced or tricked out of the defendant by physical intimidation or psychological pressure. It must also have been made freely and rationally. Obviously, a person cannot give up a valuable right freely if his brain is so clouded that he is not thinking straight. If you conclude that the defendant's level of intoxication from alcohol had rendered the defendant incapable of understanding the meaning and effect of his statement or incapable of withholding it, then you must exclude the defendant's statement from your deliberations as being involuntarily given. However, one's intoxication does not automatically make an otherwise voluntary act involuntary. You must look to all the circumstances to determine whether any statement was made freely and rationally. Each juror must determine whether the Commonwealth has proved beyond a reasonable doubt that any statement that the defendant made about the offense was made voluntarily, freely, and rationally. If any juror is not convinced beyond a reasonable doubt that the statement was voluntary, that juror may not use the statement as evidence in coming to his or her own conclusion about whether the Commonwealth has proved the charge beyond a reasonable doubt. If the Commonwealth has met that burden, then you may consider the defendant's statement and rely on it as much or as little as you think proper, along with all of the other evidence. There was evidence in this case that suggests the defendant was given Miranda warnings by the police prior to questioning. You may consider these Miranda warnings in your evaluation of voluntariness. Now, you've heard evidence suggesting that the defendant may have placed Kathleen McLean's body in a pond and weighed it down with rocks after the incident. If the Commonwealth has proven that the defendant placed Kathleen McLean's body in a pond and weighed it down with rocks after the incident, you may consider whether such action or actions indicate feelings of guilt by the defendant, and whether, in turn, such feelings of guilt reflect actual guilt on the charge in this case. You are not required to draw such inferences, and you may not do so unless they appear to be reasonable in light of all the circumstances of this case. If you decide that such inferences are reasonable, it will be up to you to decide how much importance to give them. However, you should always remember there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, for such feelings are sometimes found in innocent people. Finally, please be aware that standing alone, such evidence is not enough to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence. Let me now turn to the final part of my instructions. The first matter is that one of my functions is to appoint a foreperson for the jury, and in this case I appoint the juror in seat number 1, juror number 1 as foreperson. Let me note that you are all equal in your voices and your votes as jurors in this case, and you should all discuss the matter equally among yourselves. The reason we have a foreperson is twofold. First, the foreperson facilitates, if you will, or helps organize the discussions among the jurors during your deliberations. The foreperson has the responsibility of making sure that the deliberations proceed in a fair and orderly manner, that every juror participates, and that you listen carefully and patiently to the views of each juror. Secondly, the foreperson will fill out the verdict slip speaking for the whole jury when you have reached a unanimous verdict, and will report it in open court on behalf of the jury. Your verdict when you are ready to return your verdict to the courtroom. Okay, the next matter is the law permits only 12 people to deliberate in a criminal case. Okay, so there are 16 of you here. So shortly, we will by lot reduce your number to 12. Now, we chose 16 of you originally so that the process may properly go on to a conclusion if someone should get sick or have a personal loss in the family or some emergency. If you are chosen as an alternate, you'll be kept apart in another room from the deliberating jury, and although it may be frustrating, you may not discuss the case with one another or with anyone else. Like the deliberating jurors, you are under a continuing obligation not to have any contact whatsoever with the defendant, the lawyers, or any witness. If we get into a situation where we lose a deliberating juror because of some personal emergency or sickness, then I will send an alternate into the jury room. And so important is the role of the alternate that if I have to replace a juror, I'll tell the deliberating jury to start again right from scratch as reconstituted, no matter how long the deliberations have gone. So if you're chosen as an alternate, please do not think that your contribution here is not valued, because it is. The verdict of the 12 of you who deliberate in this case must be unanimous. That is, all 12 of you must agree whether the verdict be not guilty or guilty. 12 people must be of one mind. Let me remind you that with respect to the indictment, you may find the defendant guilty only if you all unanimously agree beyond a reasonable doubt that the charge is proven beyond a reasonable doubt. And let me just say a few words about your deliberations in the jury room. You have been permitted to take notes, and some of you have chosen to do so. You may, of course, refer to your notes to remind you of what's gone on in the trial. But keep in mind that the memory of a juror who did not take notes may be just as good. Any notes that may have been taken necessarily will be incomplete and inadvertently may be inaccurate. They are not transcripts. In your deliberations, give no more and no less weight to the views of a fellow juror just because that juror did or did not take notes. Deliberate together, not 2 or 3 of you huddled off in a corner. The use of cell phones and any other personal wireless devices is not allowed under any circumstances at any time during jury deliberations. It is probably not a good idea to take a straw vote at the outset of your deliberations. If you do that, you might think that under your oath you are bound to adhere to that initial impression, and that is not so. No member of this jury should ever attempt to communicate with the court by any means other than a signed writing. Any question you may have about this case should be in writing, signed by the foreperson. If you have a question, please state only the question and do not disclose any preliminary votes or views of the jurors. The foreperson will deliver the written communication to one of the court officers who will see to it that is delivered to me. I will call in the lawyers, we will discuss the communication and get a response to you as soon as possible, but keep in mind there may be a delay. You may continue to deliberate while we are addressing your question, or you may stop your deliberations. It's entirely up to you, but you all must agree. And remember, because I am only the judge of the law, and you are the judges of the facts, I cannot answer any questions you may have as to what the evidence was. You cannot seek an answer to any question you may have by consulting a dictionary or any other book or source of information, including the internet. The pace of your deliberations is entirely up to you. Your deliberations are to be conducted in secret. You are not to disclose to anyone outside the jury room, not even to the court, how you stand numerically or otherwise on the matters before you. You are not to discuss, even with the court officers who are looking after you, how things are going in deliberations, what people said, how you are feeling. Your communications with the court officers should have to do with matters of scheduling breaks, when you come back to the courtroom and that kind of thing. But do not, even with the court officers, discuss what is going on in the jury room. You'll note shortly as well from the oath taken by the court officers that they too, as well as any other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching the merits of this case. When you are unanimous as to your verdict, the foreperson will check the appropriate box. The foreperson will sign and date the verdict slip. When you've arrived at your verdict, the foreperson should inform the court officers, and they will bring you back into the courtroom to receive your verdict. And one last point before you begin your deliberations. Please have confidence in what you're about to do. You're all people of intelligence and common sense with many years of experience in the real world. And collectively, you bring to bear a very powerful force in determining the truth of matters in controversy. Our system of trial by jury began over 9 centuries ago in England and has lasted largely uninterrupted to the present. If it had not proved to be a very powerful institution in providing justice, it would not have lasted as long as it has. So have confidence that you, working together, will be able to arrive at a verdict in this case. I'm confident that you will discharge your duties faithfully and well. Can I see counsel at sidebar, please?
Okay, so there we go. Let me turn this down. So there were final jury instructions. I guess that's it. They go... All right, so that's it for that. So it seems like they went home because there's a day 9. So it looks like they went home. So let me just grab that link. Which makes sense because that was like almost, that was 5.5 hours. So it was probably, they started at say 9. It was like 2. You think they would have gone a little bit later, but anyway. Let me just, let's just go through quickly what we... So we had closing arguments. We had the defense come in, the state come in. It was predictable, right? We figured, the defense basically just threw Katie under the bus, and he really went after Katkowski. It allows a police investigation. He's like, cops, you can just wind them up and walk them to the stand and push the button. Did you get your check on a Friday? Yeah, he really went after Katkowski. I guess that's what they do. Yeah, he kept bringing in, Katie just wanted to, basically jump on Harry and blah, 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 The round spot on the bed was from her. I mean, just gross. There were 3 other male contributors in his bed. I don't know about that, but I guess, I don't know. Who does an Elvis drive-thru? He's got that. And then the state comes back in. He took her past her kids to the woods, placed two large rocks, discarded her like a piece of trash. Katie wasn't sure about the reconciliation, but wanted stability for her kids and to make the marriage work out. The defense suggests heat of passion or self-defense, and he snapped. I suggest it's a motive to, delete him. Kurt's text, see, this was a good point, I thought. Kurt's text shows his constant and enduring belief Katie was a vindictive devil. So, to me, he had a lot of anger pent up. He's drinking, they're drinking. And yes, he snapped, but he definitely, that's the way he felt. So if I was a juror, I'd be like, this has been boiling underneath him for a long time. Yes, he wants his house back, but there's other ways to go about doing that, you know. So, yeah, and while he was in the hospital, he didn't tell law enforcement that he was on his knees. He was begging her to stop, looking at the phone, right? She looked at the phone and saw that other Katie, you know, her texts. He didn't say he grabbed her by one hand. He said he grabbed her by the throat. He didn't tell them that he tried CPR. Defense has tried to embarrass, disparage, and blame Katie. That's just a distraction. Harry has training to react under pressure. I wish she had brought up something about his military training, because he was in the Air Force in East Germany for 18 months. You don't get into the Air Force by, we know he's an intelligent guy, right? The Air Force is like the best of the best, sir. So he had military training. He went through boot camp, I'm assuming. I don't know what East Germany does, but everybody goes into the military. So he had training. So, he knew what it would take to take somebody out. I am sure. So we had a vote. Which would you give Harry? Second degree, first degree, involuntary, or not guilty? So 0% said not guilty. 21% of you said involuntary manslaughter. 34% of you said first degree, and 44% said second degree. That's where I went. Yeah, Mel, it is mandatory, right? I think Israel does the same thing. Zach voted best burger cooker in human history by kids and friends who weren't getting any burgers until they voted thusly. Nice. Yeah, there's other parts of the world that make that mandatory. My point is, he had military service. He knew I'm sure he knew how to take somebody out. So, all right. So we have a verdict. After 6 hours, I'll let you go with that. We won't have a poll how long they've voted or they've deliberated for. I'll let you know straight away. All right, so let's get to the verdict.
Madam Foreperson, what say you as to indictment number 2020 CR 0138, charging the defendant Ingolf Tuerk with murder? Is he guilty of any offense charged?
He is.
Guilty of what?
He is guilty of voluntary manslaughter.
May the verdict be affirmed, Your Honor.
It may.
Members of the jury, hearken to your verdict as the court so recorded it. You on your oath do say that the defendant Ingolf Tuerk is guilty of the lesser included offense of voluntary manslaughter. So say you, Madam Foreperson?
Yes.
So say you, all members of the jury?
Yes.
Thank you. May the verdict slip be filed and recorded.
It may be. All right, jurors, you can be seated. On behalf of the Superior Court and the trial court, I want to thank you for your time and sacrifice. Without your participation, our system does not work. So again, thanks for your time and sacrifice. It's my practice to come thank you personally in just a couple of minutes in the jury room. You have no obligation to stay. You are discharged, but I'll be in just a few minutes if you want to stay. And I want to thank you personally for your service. Okay.
All rise, please. Your Excellency.
Did they say voluntary manslaughter? Yep. I'll pick a date for sentencing. We'll have probation sentence. I'm not going to go right into sentencing right now.
You may be seated.
All right, Ms. Beatty?
Could I just have 1 minute to consult with the family?
Yes, of course.
Is tomorrow available?
No. May I please? I would be asking that the court would order a pre-sentence investigation. So I would ask that we defer sentencing for however long it takes for probation to do that.
All right, is there any objection to that?
I don't know that I have a basis to object.
Okay. All right, do you know how long that will take?
Usually a couple of weeks, I think, for probation. I don't know if, yeah, probation's here.
I'm not sure exactly how long that is right now.
Margaret?
Yes.
My experience, Your Honor, is here in Dedham, here and in Plymouth and Barnstable, the three counties I know, generally about 2 weeks tops, 3 weeks tops.
All right, so let's put it over perhaps the week of May 5th.
May 7th, the Wednesday. But maybe we could do it at noon.
Sure.
For about a little time.
Can I just have a minute, please?
Yes. Do you want to check with the family, Ms. Beatty?
Yeah, that would be fine.
That's not a great day. I also don't have my calendar with me, I'm realizing. So can we pick a date, but then if we need to reschedule with the clerk, especially after we hear from probation about how much time we need? Mr. Reddington,
Yeah, fine.
what other day that week could you do?
Let me ask if May 15th might work. That's the following Thursday.
I'm told by probation they need a month, so that's
Okay.
May 15th? Can you or, I'm sorry, what date did you?
Whatever
May
day
15th,
you schedule is fine.
Which is a Thursday.
Okay.
Even if I'm on trial, I'm sure a judge will allow me to come here for sentencing.
You want to do it at 12 that day, Margaret?
Or,
The 12th. Okay. Does that work, the 15th, which is a Thursday? Why don't we do it at noon?
Can we do it at 2? Only because I've got like 10 cases in Fall River, Superior, and I'm just going to continue all of those and be here.
We can do the 16th at 2, if you want to do that.
16th is fine.
That's Friday.
Yep.
okay. Well, you can ask him. Okay.
I have to be in Dedham anyway. That's perfect.
So May 16th at 2?
Yes.
Stand up, sir, please.
Mr. Tuerk, the jury having returned a lesser included verdict of voluntary manslaughter, you remain held on a minimus without bail. Your matter is continued to May 16th at 2 p.m. for sentencing. Thank you.
Okay.
Your Honor.
Thank you, counsel.
Thank you, Mr. Clerk.
Thank you.
All rise, please.
Take your time.
Is he in her lobby?
Back.
Oh, okay.
All right, so that's that. I tried to find a press conference, and I could not find a press conference, although Richard McLean, so Reddington did a phone interview, but Richard McLean, who is Kathleen's brother, says essentially he's walking out scot-free. It's a shame. The whole thing took 5 years for us to get to this point, to walk away extremely disappointed. McLean's family says she is not getting justice and that Tuerk got away with basically driving down the road and throwing a piece of trash out the window, said Richard. That's what he did to my sister. What person deserves that? And then, let's see. And then, hold on a sec. Reddington gave a phone interview. Let's see, Reddington interview. Okay, let me see, here's this one. I would say that we're very pleased with the verdict, Reddington said in a brief phone interview. The jury, he said, took the time to listen to the judge and consider the evidence, ultimately making what he felt was the right decision. Still, Reddington added, all in all, no matter how you look at it, it's a human tragedy. Norfolk District Attorney didn't immediately respond to a request for a comment. So that's that. So that's pretty much it. That's pretty much it. What do you guys think? Cazador, hopefully he lost his money and house to defense attorney. Yeah. Remember, he got hit with fraud. He had to pay $150,000 because he was fraudulently billing his patients. So he's not a good guy. Does he lose his license to practice medicine? Probably. Let's see. Did Harry? Well, he was like bouncing all around. He was a consultant in Germany. Then he was down in Florida. He was living in Boston on a couch. Yeah, I don't know. Let's see. Is Dr. Harry Tuerk still practicing? That I don't know. Don't know for sure. I can't imagine that he still is, to be quite honest. Yeah, I think he's 63, so he's going to face up to 20 years. Even if he gets, well, he already, I think OnlyFan, you said, he's been in jail since 2020, since May of 2020, so 5 years basically. So already has 5 years. He may get out. Judge may give him only like a year when you think about it. When you think about that, yeah, 13th juror, I would think so too. I mean, yeah, especially now. Yeah, I don't think they're going to keep him on at this point. Cazador, he would be hard to insure. That's kind of a big deal, and he can't travel easily as a convicted felon. Yeah. Cazador says his license is active, but lots to do to get back to it. Yeah, I'm sure. Let's see. Dwayne, you're watching DUI drivers getting busted. That's always fun. It's always fun to watch somebody else. Oh, Heather, yeah, he'll go back to Germany. That could be. Yeah, I can see him going back. So, Virginia says, I would think he would have lost it when he got caught stealing from Medicare. I know he had to pay a fine and he got released from wherever he was, St. Elizabeth, I think. I know he got fined. I think it was $150. And and he got fired. I think he got fired as well. Pretty sure he got fired. Yeah, okay, it's in our description. Duh. He was at St. Elizabeth Medical Center. He was fired after the state attorney's general office found he had committed $31,000 worth of Medicare fraud. He agreed to pay $150,000 to resolve the allegations. So he was fired from St. Elizabeth's. Baca, who knows what they will allow in Germany? Mikazador, he can't go back to Germany. He gave up his citizenship. Huh. You don't think he can go back? Yeah. 150 was probably nothing. Yeah, he was making like 200. Well, I looked that up. I think it was like, yeah, the salary for Boston urologist, chief medical or whatever, was like 220, something like that. So, yeah, he probably was able to pay that back pretty well. Yeah, Irish Amy. That's an interesting gap in the CV to explain. So Zach is, you're cooking. You got some Mexican friends, did the jalapenos. They're amazing cooks, and I have something cooking the whole weekend. Nice. Therapist, you know your mouth starts burning with too much black pepper. Virginia Little, I'm not sure how you strangle someone and not get guilty. Strange verdict to me. Well, I think they proved that he didn't mean it. He was pretty contrite on the stand. You know, I think as much as I don't like him as an individual, he was, you know, he did come across as like, you know, I didn't mean it. I want her back. You know, if I could bring her back today, I would, that kind of stuff. So he didn't seem like so cold in that regard. But I think I would have gone with second degree. I don't think first. I think first may have been a little too harsh because that's like really premeditated. You really have to think about it. I think it was more second degree. That's where I landed with it. I wouldn't have done voluntary. I would have done second, but that's just me. Let's see. Valeria, he has both citizenships. He's an American citizen. Convicted felons can't just go back to Europe, especially because of the severity of the felony. They can deny entry. Okay. All right. Thank you for that. I know nothing about that, so I am definitely clueless. Drunky, you voted second degree? That's where I think that's where I would have landed. Well, 44? Most of us did. Yeah, 44%. So the majority were second degree, and then 21% of you did. I had involuntary. I'm sorry. I think it was voluntary, right? I even asked, and Ken and OnlyFans said it was voluntary because he made the decision to do it. It wasn't involuntary where he did something to cause something. He did it. So that was my bad. So 21% of you did voluntary, 44% did second degree, and then 34% said first degree. Nobody voted not guilty. And they deliberated for 6 hours. It took them 6 hours, which took them 6 hours and 2 days. So it was probably like an hour or so that first day, and then they came back. Yeah. You don't want to leave? I know. Well, sadly, we are going to have to end the stream, you guys. At some point, we will have to end the stream. Weekends are boring without the crew. I know. Sorry, guys. Virginia Little, he has been in jail for 5 years. He will probably get at least another 7, so basically a life sentence. Yeah. So he's 63. You know, it'll be like he'll be 72-ish. 70. Yeah, he'll probably be in his 70s. I wonder, I say life because prison is hard. Yeah. He's a big guy. I think he'll probably be able to handle himself, but he's an old lion, if you will. So I'm sure the younger guys will probably pick on him with his accent, but maybe he'll find a niche somewhere, and you know, who knows. Me Cazador, military here, spouses, dependents, family, find out when having to travel to visit or orders overseas. Oh, find out when having to travel to visit or orders overseas. Gotcha. Mel Stiller, I want to wish everyone a happy and healthy weekend. Absolutely. Yeah, were you guys surprised by that? Do you guys echo Zach's, or Zach, are you commenting on this, or are you commenting on Therapist You Know's sensitivities to spice? Were you guys surprised at the sentencing, or I'm sorry, at the verdict? Therapist, I hope y'all have a magical rest of the weekend. Y'all are big loved. Yes, thank you guys. Yeah, really appreciate you hanging out on a Saturday. We have 48 watching now. I think we were up in the 50s, so I do appreciate that. Monday we're going to start Christopher. Oh gosh, I forgot his name already. Christopher Shore, and that's the one in Grand Rapids. So that's going to be an intense one, but we are hoping that we can cover it and everybody will act like an adult, and we can all grow and learn and from each other and from the trial itself. So I want to say I'm looking forward to it. I am and I'm not, because it's going to be pretty emotional and pretty intense, but I think we can get through it together. So let's see. Mo in the deep end of streaming, if y'all need entertainment, there you go. Commenting on the verdict. I hear you. You'd rather watch Dinah Shore? All right, guys. I'm going to say goodnight. Goodbye. So long. Thank you for joining us. Thank you, Aaron, for making these great graphics. Thank you to our mods. They do a great job. We're not always perfect. We are human still, and we do make mistakes, but we grow from it. And I hope you guys do the same. I hope you guys learn from your mistakes, our mistakes. We all make them, and I hope that we all can grow together. And I will see you guys on Monday. I think it's an 8:30 start, so it's an early start, 8:30 in the morning. So Drunky and those on the West Coast, I don't expect to see you, but if you do want to join, that's cool. But if not, have a great weekend, and hopefully we will see you guys on Monday. Let me pull us over here. And before I let you go, we'll give you a Super Bowl moment. There's Super Bowl chilling with her little sausage, or her little chicken leg sticking out there. So that puts the wraps on another trial. Thank you guys. Appreciate you all. I can close the book on that one. And we'll see you guys on Monday. Have a good weekend. Bye.